That's without prejudice.
Thank you, Your Honor.
Thank you. Thank you, sir.
Thank you.
Court does call the case of the people versus Janine Kruger.
As folks with people.
Your Honor, Joe Simon on behalf of Ms. Kruger. Ms. Kruger, we on state your, or
So-
excuse me, on mute.
Janine Kruger.
Thank you, ma'am.
Your Honor, when we set this, you may remember clients out of state, when we set this, we were hopeful there may be a resolution, but there won't be. And we told the court we'd be requesting a continuance to the next session if that was going to be the case. And I believe that people are going to declare that they are ready to go forward.
That's correct. We've had good contact with the named victim, Margaret Anderson, who indicates that she will see trial. There's been an offer to plead no contest or guilty as charged with a deferred. And I understand that's being rejected. So we are just requesting.
I didn't formally reject. I said, I can't do that today. I need to discuss this with
I
Michael.
apologize, Your Honor. I misspoke. Just a misstatement. I apologize. So it does look like we're going to need the December dates if the court would be so kind.
Okay. And so, all right. Jury final settlement conference will be adjourned to December 5th, 2025, 9 a.m. Jury selection in this matter will be December 8th, 2025 at 8:30. What state is your client in?
Wisconsin?
Wisconsin?
Yes.
Jeez.
Well, they share similar colors to Maryland's team, so one of the colors.
Okay, so you're gonna get hurt. That red is not Maryland red. I just need you to know that.
All right.
All right,
I understand.
so, and we beat them anyway. So,
Wisconsin's, or excuse me, Maryland's good this year. Yeah.
yeah, except they gotta play the whole game. It's just, so what I will do is I will indicate this is in person. I will indicate to council, if you don't have a resolution, and regrettably, ma'am, well, it won't be regrettable. I'll need you to appear personally on that date. I'll mark it as in person. If you have a resolution, then let the court know, and I don't have a problem with Zoom. But if there's not, then,
We'll leave the offer open as well, Your Honor.
all right, very good.
And I'll be responsive to the people.
We'll do
very
it that
soon.
way. And I think she'd rather come to Michigan anyway.
Who would? Especially.
I've been to Wisconsin.
Thank you, Your Honor.
It's just a bunch of dairy farms. Kidding. All right, thank you, ma'am. Have a good weekend. Court does call the case. People
Thank you, Your
versus
Honor.
You're welcome. Court calls the case, People versus Gregory Sistra.
Morning, Assistant Public Defender Lauren Perny on behalf of Mr. Sistrunk. Your Honor, I did a little bit more digging into Mr. Sistrunk's cases.
Go ahead.
I think I confirmed that he was transported to hospice
Okay,
by the jail. That's what the notes in our files indicate. So that's what I'm saying. I think that there was final communication that he was transported.
on a furlough to,
Right.
but so, all right, the last place this was left is that he certainly needed hospice. That was the court's understanding. The only issue was he going to a facility for hospice, or was it going to be in-home house?
That I do not know. The notes by the other attorney just indicated that he was transported to hospice.
So, all right. Regardless of that, he's not in our jail. He is someplace else, presumably under hospice care.
Right, as I mentioned, I think the other day off the record, that in the jail system, it shows him being present in the jail, but the jail says he's not physically present.
Right, and I think we determined that because it wasn't a release, it was a furlough.
Right.
So he's still a prisoner
Right.
at the jail, right, or an inmate. All right, so what would you like me to do?
We're not able to proceed, Your Honor.
So I'd ask,
After all of
I
that,
know.
really, after all of that,
It felt rude to interrupt.
that was
I
like,
apologize.
an East Hope.
I apologize.
All right.
We're not able to proceed. It's a 2023 case, Your Honor, so I don't see the point.
I move for dismissal.
All right, in absentia, I will grant that. That doesn't, people being unable to proceed, this case is dismissed. Thank you.
I was talking.
No, it's okay. Good talk. Court does call the case of the People versus Safari Steel.
Ashley Phelps for the people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Miss Steele. Your Honor, I do not believe Miss Steele is present. This is Miss Pate's case, but I do not believe she has an explanation for a failure to appear.
Okay, so I need to sign off on this one. I don't think it's on the issue warrant. All right.
Your Honor, so my understanding is she was transferred. Let her go on explain. She did contact the clerk's office yesterday and said she was out of state.
Okay, did you hear all of that?
A little bit.
It really wasn't a whisper. I guess she was transferred to Wayne County. Wayne County on mistake let her go instead of bringing her back here. She did contact our clerk's office to indicate, so she's aware of the date, to indicate that she was out of state.
Okay. Well, I have no further information to add to that, Your Honor. But thank you for that information. Today's just an
You can
exchange.
thank Ann. I had no clue. All right, so I guess I won't issue a bench warrant because she at least contacted the court. She would have normally been in our facility. What I will do is I'll adjourn the jury final settlement conference to December 5th, 2025, 9 a.m. Jury selection, the 8th, 2025 at 8:30 in-person proceedings, and then allow you to get in contact with her and get her here. I'll need to sign off.
Yes.
All right,
Thank you.
thank you. Court does call the case, People versus Rodney Jones.
Good morning, Your Honor. Edward Lucas on behalf of the defendant. I'm standing in for the attorney of record, Robert Killawell.
Your name, sir?
Oronde Jones, sorry.
Thank you. No, sir.
And your Honor, at this time, the people are unable to proceed.
I would move to dismiss.
People being unable to proceed, this case is dismissed. That's without prejudice. Thank you.
Your Honor.
Thank you.
Court calls the case of the People versus Eileen Wood.
Ashley Phelps for the people.
Yeah, good morning, Tom Pietrowski on behalf of Ms. Wood, who's standing in court to my right. Good morning, sir.
Good morning. Your name?
Aileen Wood.
All right. Yes, I need you to take your hand out of your
Oh,
pocket.
sorry.
Thank you.
Yeah, we're set this morning for final settlement conference. At this time, the people are unable to proceed.
Move to dismiss.
People being unable to proceed, this case is dismissed on defendant's motion. That's without prejudice.
Thanks, sir.
Thank you. Court calls the case, People versus Kyle Lighton.
And it says on behalf of the people.
He's still appearing on behalf of and with Kyle Lighton, who's approaching.
Good morning. Morning. Your name, sir?
Kyle Layton.
Thank you.
And your Honor, at this time, people are unable to proceed.
Your Honor, we would move to dismiss.
People being unable to proceed, this case is dismissed. That's without prejudice. Thank you.
Thank you very much, Your Honor.
Thank you, sir.
And I'll apologize to Mr. Eastoe. His dismissal didn't take that long.
I'm gonna write it down.
It's right. Court does call the case of the People versus Maya Hines.
And this is on behalf of the people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Hines.
I have two cases. Well,
1487 is not stopped here also.
Deal with that case. All right, with regard to the case that's on the docket.
Sorry. With regards to that case, Your Honor, people are unable to proceed.
All right,
Move to dismiss, Your Honor.
people being unable to proceed, that case, that being 1487, that case is dismissed. That is without prejudice.
I don't think Ms. Hines stated her name. Can you state your name? Ms.
Maya
Hines?
High.
All right. I do have another case for Ms. Hines.
I don't know. You know,
In which she has a warrant. It's a case of retail fraud. You were set to appear before the magistrate, did not, a warrant was issued on that case. What I will do is this, that I'll arraign you on the warrant in the case. Ma'am, that case alleges that on or about January 7th, 2023, at the location of the Meyer store. 3825 or the other one. At the location of 3825 Carpenter Road in Pittsfield Township, Washington County, State of Michigan, that you did commit the offense of retail fraud in the third degree. Do you understand the nature of that charge, ma'am?
Yes.
All right, that is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Fine could be increased if 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. Do you understand that?
Yes.
All right. First question I have for you, you want to be represented by an attorney?
Yes.
This is a public defender case.
Assistant Public Defender Lauren Kearney on behalf of Ms. Hines will waive formal reading and stand mute to the charges.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea to that charge. I will set a pretrial in this matter for November 5th, 2025, 9 a.m. or as your invite indicates. With reference to bond in this case, I will cancel the bench warrant in this matter. I will then set a bond in this case, amount of $5,000. Personal recognizance of other standard conditions, including no assault behavior or possession of any weapons. You understand that, ma'am?
Yes.
I'll also indicate you're not to possess or consume any alcohol, recreational marijuana, or any illegal drugs at this time. You understand that? I will also indicate that at this time also, you are not to enter any Meyer store in the state of Michigan. You understand that?
Yes.
All right. Thank you. See you on the 5th. Court does call the case People versus Austin on.
And on behalf of people.
Public Defender Natalie Pate with and on behalf of Mr. On, who stands to my right. Please state your name for the court, sir.
Austin on.
Thank you.
And Your Honor, at this time, the people are unable to proceed.
Motion to dismiss.
People being unable to proceed, this case is dismissed. That is without prejudice.
Thank you, Your Honor.
Thank you. Court does call the case People versus Jalen Robinson.
And then on behalf of people.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Robinson, who is approaching. State your name, sir.
Jalen Robinson. All right. I have before me a plea form. Is that what we're doing?
Yes, Your Honor.
My understanding is the defendant is going to be pleading guilty to the as charged to domestic violence, the 93-day offense. Upon a successful plea to that charge, at sentencing, the defendant, there's an agreement that he will be sentenced under 7694A, the preferred program. That's the court's full understanding of the agreement.
Correct, Your Honor.
Correct.
Oh, very good. May I have him sworn?
You solemnly swear or affirm the testimony you're about to give be the truth, whole truth, and nothing but the truth have you got. Lower your hand and state your name.
Jalen Robinson.
All right, sir, it is this court's understanding you're going to plead guilty to the charge of domestic violence. That is a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court cost. You understand that?
Yes.
All right. And understanding that, do you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty. Guilty.
Thank you. Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form today, is that correct?
Correct.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Nope.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will
Yes.
and because you believe that you are indeed guilty of this offense?
Yes.
On the date of July 11th, 2022, at the location of 4820 Washtenaw Apartment B11, Pittsfield Township, Washtenaw County, State of Michigan. What did you do on that date involving a Giovanna DeMarco that makes you think that you're guilty?
Just touched her when she didn't want to.
Okay. Were you guys involved in a fight of some type or an argument?
Argument.
You were involved in an
Verbal.
argument
Verbal argument.
and you touched her in some fashion?
Yes. And without her consent.
Pardon?
Yes, without her consent.
Man. So you said you touched her and she didn't, where did you touch her?
More so like the waist.
All right. And you didn't have her permission to do that?
No.
Okay. And you did that intentionally?
No.
You didn't touch her intentionally.
Mhm.
He's asking if you touched her intentionally, like it wasn't an accident, like you touched her,
Like it wasn't an accident.
like you touched her,
Like on purpose.
yes,
So yeah.
yes.
Okay. Yes.
Okay. I'll ask the question again. Did you intentionally touch her when you said you touched her on the waist?
Okay. Yes.
You did? Okay. And that was without her consent, as we've established.
Correct.
Correct. And what is her relationship to you?
Right now, or nothing.
It's probably not good right now, but what was it at the time?
I'll say dating. Dating. Yeah.
I'll say dating.
Yeah. Cause we wasn't
your relationship with her?
we wasn't boyfriend girlfriend. So I'll say dating. Intimate. I don't know.
Okay, that works. All right. Sir, if I accept your plea, I do have to advise you that if you commit misconduct between the time of my acceptance of your plea and your time of sentencing, that the court would no longer be bound by any sentence agreement or evaluation of your case. You understand that?
Yes.
And also you would not be permitted to withdraw your plea. You understand that?
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
All right, and have the court complied with the court ruling would it be proper to accept his defendant's plea?
Yes, Your Honor.
Yes, Judge.
Court will accept the defendant's plea of guilty to this charge. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be November 12th, 2025, 9 a.m. Bond in this matter with its conditions. will continue. Thank you, sir. You can stop by probation on your way out the hallway. They'll be on your left.
Okay.
All right, thank you. Court does call the case, People versus Samira, is it Takora?
Alexander on behalf of the people.
Assistant Public Defender Natalie Pay on behalf of Ms. Takora, who I do not know or if she's present, Your Honor. I have had, oh, perfect, she's here. Let's talk on the phone. Ms. Takora, I apologize. Please state your name for the record. Samira Takora.
Thank you.
Sir, at this time, people are unable to.
Motion to dismiss, Your Honor.
People being unable to proceed, this case is dismissed. That's without prejudice. Thank you, ma'am.
Thank you, Your Honor.
Court does call the case of the People versus Nicholas Stimmel.
That's false for people.
And good morning, Your Honor, for the record.
Yep.
Good morning, Your Honor. For the record, Rita Young, appearing on behalf of Mr. Nicholas Stemmel, who is present standing to my right. Sir, would you state your name for the judge?
Nicholas Stimmel.
Thank you. I thought since you hadn't been here in so long, Michelle, you just forgot where to stand.
Kinda.
It is good seeing you.
Likewise, Your Honor.
All right. I have before me a plea form that indicates that the defendant will be pleading no contest to the charge of assault and or assault and battery, the 93-day offense. On his successful plea to, that's pleading as charged, there is an agreement as to sentencing that a prosecutor's deferred sentence with probation would be the sentencing case.
That is completely correct presentation of our agreement.
And Your Honor, it's my understanding that if successfully complete probation, the case will be dismissed.
That's right.
As part of the prosecutor's deferred. That's correct. All right. May I have him sworn?
You solemnly swear or affirm the testimony you're about to give the truth and nothing but the truth, so you got.
Yes, I do.
Lower your hand and state your name.
Nicholas Stimmel.
Sir, it is this court's understanding that you're going to plead no contest to the charge of assault and or assault and battery. That's a misdemeanor punishable by up to 93 days of jail, $500 fine plus court costs. Do you understand that?
Yes, Your Honor.
All right. Do you understand what a no contest plea is?
Yes, Your Honor.
All right. Two things about it. I have to make sure that you understand it. First of all, means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, Your Honor.
The second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
All right. Still, basis for the no contest plea.
Civil liability,
All
possible.
right. Still wish to plead no contest?
Yes, Your Honor.
And to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any questions regarding any of those rights?
No, Your Honor.
Please look at paragraph 5 on that form. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty or pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will.
Yes, Your Honor.
And well, I won't ask the last question. The court has been provided Pittsfield Township Department of Public Safety report for their case number 24-16014. Any objection to the court having reviewed that report?
None from the people.
None from the defense, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, after I accept your plea in between the time of your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, you would, any sentence evaluation or recommendation to the court would no longer be bound by. You understand that?
I understand that, Your Honor.
And you also understand that you would not at that time also be allowed to withdraw your plea. You understand that?
Yes, Your Honor.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
None, Your Honor.
None, Your Honor, and it sounds like the court's not amenable to immediate sentencing.
I wasn't asked, but
Oh, okay.
by being asked, no. All right.
Yes, sir.
You just don't want to come back here, do you? No, you're just trying to make it like a one-stop. I couldn't do that in any event because of the nature of the charge, and it's a victim's rights case, so I'd have to have him evaluated on that. But have I complied with the court rule?
You have, Your Honor, as usual.
Yeah, right. Court will accept the defendant's plea of no contest to this charge. Defendant is referred to probation
Thank you, Your Honor.
for a pre-sentence investigation and report. Sentencing in this matter will be November 12th, 2025, 9 a.m. or
Judge-
slide indicates.
I'm
That's
so-
why we don't let her come. Go ahead. What?
I'm so sorry. I have a jury trial scheduled to start in Wayne County on November 10th. And it's a CSC case, so it's going to run through the 12th, I'm sure. So I'd ask for a different sentencing date, please.
You know, I almost want to say no.
Can I zoom in for sentencing then?
No.
Okay.
No. We're gonna make you come here.
Very well.
Can we? The 10th?
10th is when the jury trial starts.
Can't
Oh,
do-
December
can't-
10th, you said? Oh, that's great. Perfect.
Sure.
Yes, Your Honor. Perfect.
Sentencing will be December, actually, the 12th was perfect too, but you just messed that up. December 10th, 2025, 9 a.m. or as your invite indicates, bond with its conditions will continue. Thank you, sir.
Thank you
Your
so
Honor.
very much, Your Honor. Good to see you.
Take care. Court calls the case of the people versus James Baltes.
And then on behalf of you.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Baltas. State your name for the record, sir.
James Lee Baltus.
Thank you.
At this time, you are unable to proceed.
Move to dismiss.
People being unable to proceed, this case is dismissed. That is without prejudice.
Thank you, Your Honor.
All right, thank you, sir.
Thank you.
Court does call the case, people versus Jason Eckel.
The people.
Good morning, Your Honor. Robert Goldman, PA 1222, appearing on behalf of alongside defendant Jason Michael Eckel, present in the courtroom this morning. Mr. Eckel, would you please state your full name for the record?
Jason Michael Eckel.
All right. The plea form that the court has in front of it is that the defendant is going to plead to an added count 2 of operating while visibly impaired to second offense. The 1-year offense. Upon the successful plea to that charge, count 1 would be dismissed. Defendant is also agreeing to enter and participate in sobriety court. Is there a particular sobriety court that he's going to be entering, or?
I'm not sure that he's been screened yet, Your Honor. Counsel and I had the chance to discuss this morning, and he let me know his client's interest in sobriety court. And given some of the facts and background here, I think that's a really good option.
Got
So
it.
I don't know that he's been screened.
Screened as, okay, but he does agree to do that. Is that correct, counsel?
Yes, Your Honor. And he is a resident of Ypsilanti. And so
You're not, right?
I'm not, no, Your Honor.
I could tell by the way you said Ypsilanti, but go ahead.
Sorry. So we are open to a sobriety court that has room for admission. I do believe that he would qualify as a resident of Washtenaw County. And otherwise, we anticipate it to be a successful screening for admission.
Okay, and I mean 14A has a,
Yeah.
I think that would be a good place to start is 14A.
Yeah.
okay. And that's the court's full understanding of the agreement. Is that correct?
Yes, Your Honor.
Accurate, Your Honor.
All right, may I have him sworn?
Do you solemnly swear or affirm the testimony you're about to give the truth, whole truth, and nothing but the truth, so help you God?
Yes.
Lower your hand and say your name.
Jason Eckel.
Say that again. You.
Jason Eckel.
All right. Sir, it is this court's understanding that you're going to plead guilty to the charge of operating while visibly impaired second offense. That is a misdemeanor punishable by up to 5 days to 1 year in jail, up to $1,000 fine plus court costs. The court could order community service or any rehabilitative services the court deems necessary. The court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, sir?
Yes, Your Honor.
And understanding that, you still wish to plead guilty.
Your Honor.
And to that charge, how do you?
Guilty.
You understand that by pleading guilty, you'll not have a trial of any kind.
Correct.
You signed an advice of rights form, is that correct?
Yes.
Any questions regarding any of those rights?
No.
Please look at paragraph 5. Those are your rights, which are part of a trial. You understand by pleading guilty of those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threaten you or coerce you?
Besides my wife, no.
All right. You're doing this voluntarily
Yes.
of your own free will
Yes.
and because you believe that you are indeed guilty.
All right.
On September 4th, 2024, at the location of 3900 Carpenter Road, Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, remember the questions we went through?
Yes. Yes.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes.
What you have and how much?
Mike's Hard Lemonade, about 3/4 of a tall boy.
Okay. Were you stopped by the police or was there an accident?
Your Honor, there was a welfare check was conducted. Officers responded by way of a dispatch for welfare. Mr. Eckel came into contact with officers in the parking lot of a Lowe's retailer in light of the welfare check response.
Got it. Okay.
No accident involved, Your Honor.
And ultimately, were you arrested
Yes.
and were you taken to the hospital for a blood draw?
It's an intoxilizer case, Your Honor.
All right. And were the results of that intoxilizer 0.09 and 0.10?
Yes.
Do you have any reason to dispute those results? Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes.
All right. And had you previously been convicted of operating while intoxicated on or about December 6, 2021 in the 1483 District Court?
Yes.
All right. Sir, if I accept your plea, between the time of my acceptance of your plea and the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to any sentence evaluation or recommendation. The court would no longer be bound by that. You understand that?
Yes, Your Honor.
You also understand that you would not be entitled to withdraw your plea.
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
None, Your Honor.
All right. And has the court complied with the court rule? And would it be proper to accept this defendant's plea?
The people are satisfied.
So satisfied, Your Honor.
All right. Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant is referred to Von Swartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be here on November. I'll set it for November 12th, 2025, 9 a.m. Bond will continue with its conditions. What I'm going to suggest to you, counsel, is to go down to probation at this point in time, indicate his interest in sobriety court, and see. There are 2 probation officers working down there at this point, my probation, as well as the sobriety court probation person. So let them know that and let them direct you as to how he should proceed.
Will do, Your Honor. Thank you.
Thank you. Court calls the case, People versus Eric Buckner.
Alexander, on behalf of people.
Assistant Public Defender Natalie Pate with on behalf of Mr. Buckner, excuse me, who stands to my right. Please state your name for the record, sir.
Eric Buckner, how you doing today, sir?
Thank you. I have a plea form indicates the defendant is going to plead to domestic violence second offense, the 1-year offense as charged. And that upon his plea, the prosecutor will recommend defendant's pending domestic violence case in the 1482 district court will be dismissed with a nod.
That is the complete understanding of that agreement, Your Honor. Yes.
All right, very good. May I have him sworn?
Solemnly swear or affirm the testimony you're about to give be the truth, whole truth, and nothing but the truth. So help you God.
Yes.
Lower your hand, state your name.
Eric Buckner.
Sir, it is this court's understanding. Excuse me one moment. This is court's understanding that you're going to plead guilty to the charge of domestic violence second offense. That is a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court cost. Do you understand that?
Yes, Your Honor.
And understanding that you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No, sir.
Look at paragraph 5. It's on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes, sir.
And because you believe that you are indeed guilty of this offense?
Yes, sir.
On the date of May 2nd, 2025, at the location of 3000 Carpenter Road, Pittsfield Township, Washington County, State of Michigan, what did you do to Tamika King that makes you think that you're guilty?
We ended up getting into a physical altercation.
So, okay, so you were in an argument,
Yeah.
and what did you do with reference to that physical altercation?
It got physical.
Pardon?
Me and her, it got physical.
Okay. What did you do?
Oh, I put my hands on her. That's basically what you're saying, sir.
Okay. And you didn't have her permission to do that?
No, sir.
All right. And you weren't acting in self-defense at the time?
No.
All right. And you did that intentionally, is that correct?
Yes.
All right. And who is she to you?
My ex is my ex-wife.
At the time, was it your ex-wife?
No.
Okay, at the time it was your spouse.
Yes.
All right. Had you previously been convicted of the same type of an offense on or about, I don't have it here.
Your Honor, I have the date on the offense numbers of 6/18/2013. The previous.
6/18/2013. All right. Had you previously been convicted of domestic violence on that date?
Yes.
All right. Sir, if I accept your plea, between the time of my acceptance of your plea and the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to any sentence recommendation or evaluation. The court would not be bound by that. You understand that?
Yes, Your Honor.
And you understand that you could not withdraw your plea.
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements which had led to this plea?
No, Your Honor.
No, Your Honor.
And has the court complied with the court rule? Would it be proper to accept the defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea to this charge. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
November 10th. Oh, no, November 17th, sorry.
November 17th, 2025, 1 p.m. What I was going to indicate, I don't know if on that other DV case, I think we got the wrong date.
We corrected it.
You corrected it.
Yes.
Okay, very good. All right. Bond will continue with its conditions. Thank you, sir.
Thank you, Your Honor.
Court calls the case, People versus Christopher Banks.
Ash Phelps for people.
Public Defender Natalie Pate with and on behalf of Mr. Banks, who stands to my right. Please state your name for the record, sir.
Christopher Banks.
Thank you.
Paragraph 6, morning for final settlement. This time people are unable to proceed.
Motion to dismiss.
People being unable to proceed, this case is dismissed. That is without prejudice. Thank you, sir.
Thank you, Your Honor.
Thank you.
Good here.
There you go.
Okay.
Both are.
Court does call the case of the people versus Uris Hernandez. We have an interpreter. May I have the interpreter sworn?
Raise your hand. Do you solemnly swear or affirm that you will interpret accurately, completely, and impartially using the best skill and judgment to translate from English into Spanish and from Spanish into English in the matter now before the court, so help you God?
I do.
All right. Thank you, sir. Good morning. Go ahead, Counsel.
Nash Feldes for the people.
Fiscalía.
And Assistant Public Defender Natalie Pate with and on behalf of Mr. Hernandez, who stands to my right. Please state your name for the record, Mr. Hernandez.
Luis Hernandez.
This time, the people are unable to proceed.
Fiscalía, ¿me puede proceder?
Motion to dismiss.
People being unable to proceed, this case is dismissed. That's without prejudice.
Thank you, Your Honor.
Thank you. Thank you, Mr. Interpreter. Court does call the case, people versus David Wagner.
Nash Feldes for the people.
And Assistant Public Defender Natalie Pate with and on behalf of Mr. Wagner, who is approaching. Please state your name for the record, sir.
David Charles Wagner Jr. Thank you.
Some people are unable to proceed.
Motion to dismiss.
People being unable to proceed, this case is dismissed. That is without prejudice.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you. You have a good day. You do the same, sir. Court calls the case of the people versus the Darien. It's Stephanie Town
Nash Feldes for the people.
or Stephanie Town.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Staffney Towns. State your name for the record.
Padarian, Townsville. I really don't go by Staffney. I got two last names, but I really only go by Townsville.
But you got two names.
I don't know why my mom did that.
You don't know what?
Why my mom did that.
But you don't like it, so you just keep one?
Yeah. I'm sorry. I just keep one. Yeah.
Is it the first one or the last one?
The last one, Townsville. Padarian Townsville is what I go by. But Staffney Townsville.
What's your mom say about that?
Like, my mom's last name is Townsville. My dad's last name is Staffney. So she just gave me both.
Oh, what's your dad say, but you don't want to carry his name?
No.
Oh, well, never mind. My bad for asking. All right. Okay. I get it. All right. What are we doing on his case?
Unable to proceed, Your Honor.
Move to dismiss.
People being unable to proceed, this case is dismissed.
All right, thank you.
That's without prejudice. You take care of whatever your name is. All right. Court calls the case, people versus Giselle Safer.
Nash Feldes for the people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Seyfried. State your name.
Giselle Seifert.
You're here today for a final settlement. This time, people are unable to proceed.
Move to dismiss.
I've never said your last name. Sorry.
People being unable to proceed, this case is dismissed. That is without prejudice.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, ma'am. Court does call the case of the people versus Lucille Slater.
Nash Feldes for the people.
Apologize about that, Your Honor. Assistant Public Defender Natalie Pate with and on behalf of Ms. Slater. Please state your name for the court, ma'am.
Lucille Slater.
All right, I have before me a plea form indicates that the defendant will be pleading no contest to the charge of disorderly person jostling the 90-day offense. Upon their successful plea to that charge, count one would be dismissed. There is a sentence agreement between the parties of a prosecutor's deferred sentence. That's the court's full understanding.
That is correct, Your Honor.
And that is our full understanding of the agreement as well, Your Honor.
May I have her sworn?
Do you solemnly swear or affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Go ahead and state your name again.
Lucille Slater.
All right, ma'am, it's this court's understanding that you're going to plead no contest to the charge of disorderly person jostling. That's a misdemeanor punishable by up to 90 days in jail, $500 fine plus court costs. You understand that?
Yes,
Do you understand what a no contest plea is?
yes.
All right. Two things about a no contest plea I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest this charge. You understand
Yes.
that? Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
All right. Basis for the no contest plea.
Potential civil liability, Your Honor.
All right. And ma'am, to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes,
You signed an advice of rights form, is that correct?
yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading no contest, you're waiving or giving up those rights as well as all the rights contained on that form.
Yes,
You understand you're giving up your right to appeal of right.
yes.
Are you on probation or parole?
No,
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
no,
Anybody threaten you or coerce you?
no.
You're doing this voluntarily
Yes,
and doing it of your own free will.
yes.
All right. Court has been provided and has reviewed Saline Police Department report for their case number 25-1760. Any objection to the court having reviewed that report?
No, Your Honor.
No, Your Honor.
All right. Ma'am, based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Ma'am, if I accept your plea, I do have to advise you that if you commit misconduct between the time that I accept your plea and the time of sentencing in this matter, that you would then not be entitled to any sentence evaluation or recommendation. The court would not be bound by that. You understand that?
Yes,
And you would not be permitted to withdraw your plea. You understand that?
yes.
All right. Are the people or is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
All right. And has the court complied with the court ruling? Would it be accepted?
Before that,
Yes, Your Honor.
Court will accept the defendant's plea of no contest to this charge. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
November 12th at 9 a.m.
November 12th, 2025, 9 a.m. or as your invite indicates. Bond with its conditions will continue.
Thank you, Your Honor.
Court does call the case, People versus Anthony Williams.
And is that on behalf of the people?
And this Assistant Public Defender Natalie Pickwick, and on behalf of Mr. Williams, who stands to my right, please state your name for the record, sir.
Anthony Williams.
Your Honor, I believe we're going to be looking for an adjournment to December. We're working on a resolution, but through my own fault, I need to run some things by my supervisor before offering a potential resolution. So I'll be asking for an adjournment out to that date.
The objection to that?
No, Your Honor, and I have discussed that and the reasons for that with Mr. Williams, and we are in agreement of the adjournment to the December date.
I will adjourn jury final settlement conference to December 5th, 2025 at 9 a.m. Jury selection, if necessary, will be December 8th, 2025 at 8:30. Both of those proceedings are in person. All right, thank you, sir. Bond continues. Court calls case People versus Shanice Greer.
That's the bills for the people.
Morning, Your Honor. Edward Bruce on behalf of Shanice Greer. I'm standing in for the attorney of record, Robert Kilwell.
All right. Good morning. Your name?
Denise Greer.
All right. Okay.
Your Honor, we are unable to proceed.
I would move to dismiss.
All right. And ma'am, you have no objection to Mr. Durga stepping in for your,
Oh, no, no objection at all.
all right.
It's very kind and considerate of you. Your Honor. Kilwell did say that you are very kind and considerate.
Is that what? I've got a whole week without hearing that. People being unable to proceed, this case is dismissed. That's without prejudice. Thank you. ma'am.
Thank you.
Thank you.
Let's call the case People versus Isa Awad.
Ashley Feltus with people.
Good morning, Your Honor. Let's afford on behalf of Isa Awad. Oh, sorry.
All right. Okay, and your name, sir?
Isa Awad.
Thank you.
Your Honor, this time people are unable to proceed.
Thank you. We ask that the matter be dismissed.
People being unable to proceed, this case is dismissed. That's without prejudice. Thank you.
Thank you.
Thank you.
He wants me to ask you
Yes.
about getting the dog back.
It's my
About what?
Is he free to sue getting the dog back?
It's my daughter's birthday this month. She's been asking about it ever since I had.
I think the dog is in the custody of the Humane Society, so he's gonna have to sort
But I
that.
think what I'm asking for is that there will be no order preventing him from getting the dog back since the case. Yes.
I'm not gonna order that. The case has been dismissed. But you're gonna likely have to deal with the Humane Society regarding that.
Can I ask what's in the bond conditions?
What was in his bond conditions? Are you saying regarding animals or just?
Contact with the dog, or ability to regain custody.
His only bond condition that looks like it deals with animals, that he couldn't go to the area of the Blue Pearl and that he was not allowed to possess any animals, but
Right.
those would disappear because
All right, and how do we get a copy of the dismissal?
they can get that up front. Yeah.
Okay, thank you.
Thank you.
so much, Your Honor.
Thank you, sir. Court does call the case People versus Alexis Brown.
Ashley Feltus with people.
Is Lonnie said that she's email to her? I see. But you didn't indicate the phone.
Assistant Public Defender Lauren Perny on behalf of Ms. Brown. I think what the court is discussing is Ms. Brown at her last hearing said she did not want the public defender's assistance. However, since then she has changed her mind. So
And I did not, I don't think, order that you were off the case, so you were still on it regardless. So
great. Well,
I understood what she said to me, but
she's
I did
here.
not order.
State your name. Alexis Brown.
All right.
At this time people are unable to proceed.
Move to dismiss. I did a lot of heavy lifting.
What'd you say?
I did a lot of heavy lifting on this one.
Yeah, okay. People being unable to proceed, this case is dismissed. That is without prejudice. Thank you.
Thank you.
Thank you.
Court calls case People versus Keyshawn Jorgensen.
Ashley Feltus with people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Jorgensen.
Two cases, no, one case.
Your Honor, Mr. Jorgensen is represented by Ms. Stefan, so I am appearing for this hearing only. I guess at his last pretrial when this was set, Ms. Stefan knew she was going to be out of town
Yes.
and asked the PD to step in. So I'm here. However, Mr. Jorgensen not.
Okay. And what I will do is I will issue a bench warrant for his failure to appear. And just so that clearly what is going into the court's mind is he also has a warrant on another 14A1 case, so bench warrant will issue bond setting amount of $25,000. I'll give a 10% privilege on that. That warrant will issue immediately.
I'm not sure if anything else is ready. We're down to full.
Anything else ready or?
Shushendi, which I'm sure I mispronounced, but I know which we're talking about.
Okay.
Sorry.
Court does call the case of the people versus Matthew Sydney.
Shemshadini.
Shemshadini.
Shemshadini. Our first conversation, we practiced it. I kind of, about 50% of the time, get it right. So sorry, Assistant Public Defender Natalie Pate with and on behalf of Mr. Shemshadini, who stands to my right. Please state your name for the record, sir.
Matthew Shemshadini.
All right.
And Your Honor, Ashley Phelps from People, if I didn't already say that, Your Honor, in this case, while the named victim is the defendant's sister, she did not appear this morning. The parents of both parties did, but at this time, I can't represent that I could go to trial, so I'm going to say at this time, I'm unable to proceed. There is a very good chance the case may end up being reauthorized, but at this time, I cannot represent that I can proceed.
Motion to dismiss, Your Honor.
This time, people being unable to proceed at this time. This case is dismissed. That's without prejudice.
Thank you, Your Honor.
All right, thank you.
Thank you, Your Honor.
Okay, we ready on anything else or?
Ready, Mr. Nalepka.
And Mr. Hop, I think we're ready.
I just have to run back on Mr. Hop and get signatures and stuff, so I need a few minutes on that.
Okay, you're in custody, you mean?
Yeah.
All right,
So I'll go do that now.
okay. Is your client in custody or no?
Yes, Your Honor.
Okay, so I'll wait, or we can, I don't know how many people we've got back there.
That would
Somebody,
be quick.
which one?
Mr. Bernstein's client.
Okay, let's get him out then, and then you can go back. I just didn't want them jammed up back there. I didn't have a lot of folks.
Yes.
What is? That's probably likely gonna be a setting of paperwork.
Yes, sir. That's my
Okay.
We're down just.
Just use on that. Okay.
It does come down 8%. True. Okay. Don't go. No, that's not. I don't do a lot of things.
Notice you guys at the table.
That's ours.
I'm not gonna take your table, I'm just admiring the table, suggesting we get a table.
Sorry.
I swear. I don't know how I came out, that was gonna steal your table, I'm gonna steal the table. Roll out IKEA, get my own table.
Court does call the case of the people versus Gary Nalepka.
Ashley Phelps for the people.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Nalepka.
Your name, sir?
Gary Nalepka.
Thank you.
Your Honor, was it this morning for final settlement conference, the people are not going to be proceeding to trial.
Move to dismiss, Your Honor.
Case is dismissed. That's without prejudice. Thank you. I have that one, and then what's the other one?
So the last one is Miss Londi, I believe, Miss Pate.
It's paid what?
I believe Miss Pate on.
I don't know. I have an idea.
Do we know what we're doing on Burke?
I need to talk to Miss Pate. I have an
Got it.
idea. I think
All
that
right. So while Ms. Parney's getting that paperwork signed,
I'll go talk to Miss Pate.
it's paid, and then the court's gonna stand in recess and
Reach out.
they're ready. All right?
Thank you. All right.
We have a resolution of the underlying case.
Okay, good morning to you. Dale Owens.
Ready. Antonio Lee has returned.
Antonio Lee, let's go back on the record with Antonio Lee. And Mr. Lee, can you state your name for the record, please?
Unmute your device, Mr. Lee. Your name.
Antonio Lee.
Judge, this matter is here for a pretrial. My client is advised of his rights. He wishes to waive his right to a jury trial and asks that the matter be set for a bench trial, please, and thank you.
Okay, trial date, Mr. Lee, is going to be November the 10th, 2025 at 9 a.m., okay?
Thank you, Your Honor. Have a good day, Mr. Lee.
All right, thank you.
Bye now. That would make us ready on Michael Owens.
City of Detroit versus Michael Owens, case number U69656124. Appearance for the record, please.
Harry Boffman for the defendant. Sir, give the court your full name.
Michael Owens II.
Would you allow this matter to proceed to trial? The defendant's continuing a not guilty plea today and is aware of his right to a jury trial, but he wants to waive that here and now.
All right, Mr. Owens, I'm going to give you a trial date for the same date, November the 10th, 2025 at 9 a.m. If there's no further, sir, I wish you the best of luck. Have a very good rest of your day.
Thank you, Your Honor.
Thank you, Your Honor.
Will that be it, Mr. Bachman?
Well, I'm going to stay in the main session, Your Honor, with your permission. I do have Destiny Owens. She should be checking in any moment now. I'm going to call her.
All right, I had an iPhone here. Let's see who that iPhone is. iPhone, I'm asking you to start your video, unmute yourself and state your name, please.
Precious Gifts.
Not you, Ms. Giss, we already spoke. I'm sending that prompt to the iPhone now. They should see that prompt. You have no choice but to start your video, unmute yourself, so it's not an option. What is your name, ma'am? That Miss Graves there.
Yes, Destiny Grace.
Morning to you.
Good morning.
What's your date of birth, Ms. Graves?
March 16th, 1999.
Now, Ms. Graves was not on the docket, Mr. Baldwin, so what was supposed to be done?
I'm sorry?
Your turn. Mr. Baldwin? All right, let's, Mr. Berry, are you ready on, who would you have?
Mr. Long, Your Honor, ready.
Mr. Long, let's go back on the record with Mr. Hiram Long. Mr. Long, I'm giving you an opportunity to speak to counsel. Counsel, what the client want to do?
Your Honor, my client would avail himself of the people's offer to allow him to enter a plea to failure to display for the commercial motor vehicle matter, the no insurance matter to be dismissed.
Want to take the deal, Mr. Long?
Yes, so, yes, I will, Your Honor.
You guess? Yes.
Yes,
no?
yes,
All right.
yes, I will, Your Honor.
Can you raise your right hand, Mr. Long?
Right hand up, sir.
Do you swear or affirm to tell the truth, whole truth, and nothing but the truth?
Yes, I will.
Or you can put your hand down. Do you understand the maximum possible penalty for this offense is 93 days in jail and or $500 in fines?
Yes, I do.
Understand that you have an absolute right to a trial?
Yes,
Barry went over your other advice or rights in the breakout room, did he not?
yes, yes, he did.
And you understood those rights?
Yes, I did.
You have any questions about those rights?
No, I do not.
You know by taking the deal, you're gonna give those rights up?
Yes, I do.
Has anybody offered you anything other than what's been stated in the record?
think 0000766. Defendant is present in open court today with his counsel, James Reardon. Your Honor, we're here today for sentencing. The defendant was last before Your Honor on September 12th of 2025, where he pled guilty by way of information to one count of failure to notify change of telephone numbers or internet identifiers, registration of new telephone numbers or internet identifiers, felony of the 4th degree. At that time, a pre-sentence report and psychological evaluation were ordered. The state's understanding that those were completed and provided to the court, and that all parties are prepared to go to sentencing at this time. Thank you.
Thank you, Mr. Reardon.
Your Honor, that is accurate. I have received and I did review both the pre-sentence report and the evaluation done by the court's evaluator. Starting with the evaluation, the recommended course of action was based upon apparently Mr. Bailey has issues with anxiety disorder, potentially, I think it was cannabis and alcohol possible disorders, and that perhaps he had not been really examined or evaluated for those things in the past sufficiently. So the evaluator strongly recommended that the court order further evaluation for him and that he follow any and all recommendations for treatment so that he can be sufficiently rehabilitated and continue to abide by the court's orders going forward. I do believe in this.
Well, but he's demonstrated he's not interested in doing that, right?
Well,
because he's got an order. He's got an order that was in effect in the midst of a 25-year order that he didn't pay attention to. Why would he follow other orders?
Well, I believe that he will, and I believe that this
history demonstrates he won't.
I understand the court's position on that, and he admits, and we admit that he violated the order. That's why we're here, and he did. But since that time, meaning since the violation, and we've been to court, and we're doing, and he's doing what he needs to do to make sure it doesn't happen again. And the evaluator had a very in-depth interview with him and review of his history. And again, for whatever professional expertise that person has, is recommending that he do those things, and he will, if the court gives him the opportunity. Otherwise, as to the PSR and the community control, I believe he is amenable to community control. I believe he will follow your orders going forward. He will. He is not going to violate. He will. He understands. He has his family. He has support. He has those who have stuck by him. They know what he's done, and they have decided to stick with him. He has 3 children, 3 minor children that he supports, that need him. His family needs him. The court has the ability to incarcerate him at any time. The court can incarcerate him. Today, the court can, yes, absolutely. You could send him away today, but you can also give him a chance to continue to do what's right for his family. And again, I understand the history aspect of it. Right, he did not. He did not. But this is a real strong further kick in the ass. It definitely is. And his family needs him, and he works, he does work, and he does support them. He does have good support. He has a really good chance of complying and rehabilitating and doing the right thing here. And the court can, the minute he screws it up, if he screws it up, the court can send him away. But I believe he at least deserves that chance in this circumstance. I believe he does. And the others around him believe he does too. And they know what happened. They know about all the activity, about the bogus phones, about the text messages. They know all about it. And he knows all about it. He knows it was wrong. He does.
Well, I don't know that he does, or he wouldn't.
How is he receiving services?
He's outpatient.
We'll see you the 17th.
I haven't been able to text you.
Do you have the same number? Or different
Yeah.
number? Okay.
So if you could shoot me.
I'll shoot one that we have. All right.
State of Ohio versus Megan Lynn, case number CRB 25-661, A and B, set for arraignment. You're up.
Yes, sir. Thank you.
And are you Megan's name?
Yes, sir.
Ms. Lynn, were you here while explaining the rights that defendants have?
Yes, sir.
So you understand your rights?
I do.
I'm going to go over the two charges with you. There's two, 661 A and B. The A case is a domestic violence charge. It alleges that at Tepe Township on October 16th, knowing tried to cause physical harm to Robert Boca, and that Robert's either a member of your family or lives in your household. That's a first-degree misdemeanor domestic violence, maximum penalty 6 months in jail, $1,000 fine. Is Robert Boca here today? Okay, apparently not. The B case is criminal damaging. It alleges at the same time employees knowingly caused a risk of harm to property of Robert Boca without his consent. That's a first-degree misdemeanor criminal damaging charge. Maximum penalty 6 months in jail, $1,000 fine. Do you understand the two charges, ma'am?
I do.
How do you wish to plead?
Not guilty.
Do you want a lawyer appointed for
Court appointed attorney, please.
Are you working?
I am.
What do you do?
Shakery in South Point.
Are you paid by the hour? How do you get paid?
Hourly wage and tips. $8 an hour, and then I keep my tips.
I have to determine your gross annual income. Do you know what that would be?
I have paychecks double my phone.
Do you have children?
I do.
How many?
2.
Okay, you're going to be eligible, so. I'll appoint Mr. Steyer to represent you. Not guilty plea is entered. She has a bond up, oh yes, she has a bond up. Her bonds continues.
Now, we say what she's posted bond, that she's been fingerprinted.
Yes, sir.
Protection order requested.
We'd like to know what the circumstances are, if they were living together.
We were living together. I'm sorry.
And whether she can go home or not.
You have somewhere to go.
My house. He left.
Okay, he's left the house.
So we'll ask for a protection order just to.
Is it any problem for you to stay away from him?
No.
Okay. So I'm gonna order that just so that
Okay.
nothing further is alleged to happen.
That's perfectly
Stay away
fine.
from him. If he comes around you, he's not here for me. Need to order him to do anything. If he
Mhm.
comes around, you retreat, go in your home, call the police.
Gotcha.
Don't try to engage with him.
No, I made the mistake the first time. Sorry.
Please, don't say that.
I'm setting pre-trials in November. About the only date that's booked out is the 7th. Any other date in November is good.
Let me take a look at my calendar, Your Honor. Got a bunch of trials in November. I've got the 17th. Is Monday or Friday, Matt, for you?
Nope.
Okay. 17th, 21st, 24th, and 28th. Well, 28th won't be a day, but 17th, 21st, and 24th are all available.
Let's do the 17th. November 17th will be the next hearing.
10 o'clock.
It'll be a pre-trial at 10 a.m.
No, you hang on. I'll give it a call, of course. Probably a copy for myself.
Federal Highway, Vicky Wilson.
Got
Case number CRE 25-537, set for a regular. Vicky Wilson.
He's got it. Mr. Stratton actually represents Mr. Wilson. Full set for a preliminary hearing on September the 19th, unless Mr. Wilson did not appear. There was a warrant issued at that point.
Take your hat off, please, sir.
So what I think probably needs to happen, I have a report from Morris County Recovery. It's letting you talk with Mr. Wilson, Mr. Stratton, and we'll recall him after that happens. So he's been out of pocket since September the 19th.
Okay. Hey, we'll have a seat alcohol right now.
That's the bail say when you're ready.
Yes.
State of Ohio versus Bruce Curry, case number CRP 25-124.
Mr. Stratton's case, pre-trial today.
Things going well?
Yeah.
He's at RRS.
It's a little spotty. It's just good work and stuff.
All sort of work related stuff.
Yeah.
Okay. I believe he's going to improve, well, he's already improved after discussion with them. I think it's a lot of work related issues there, Your Honor, that he's currently working through. So, but he's, sounds like he's back on track.
It sounds like we still got stuff to work on.
Yes.
Yes. Mid to late November, what's your schedule?
Any days except the 3rd, 10th, and 24th, so.
21st?
Yep, 21st.
November 21st will be the next hearing for Mr.
Right. Thank you. Thank you, Your Honor.
You're welcome.
State of Ohio versus Adam Searles, case number CRB 25-646, A and D. And then we'll have versus Courtney Stiles, case number CRB 25-35. The latter case is Mr. Steyer's case.
Mr. Steyer represents Courtney Stiles and Mr. Adams. There were some issues about personal property and those been resolved.
I don't know if they've been fully resolved. Apparently, he still has your social security card and has refused to return it, is what I'm being told. So I'm going to ask that if he has the social security card, that he return it, any documents, any identification documents of hers that he returned.
Judge, there's a pending divorce. I think that's probably better for that. My understanding is he complied with, I haven't had an opportunity to talk to him about that, but my understanding is the court ordered him to give her her clothes and her medications. And he's done all that.
And why would you want to keep the social security card?
I'm not suggesting that he even has it, Your Honor, or has looked for it. I had an opportunity to go through that with him today, but there is a pending divorce. I believe she has other counsel.
And there are other matters of property that I've told her we can't deal with, but I don't think it's unreasonable to ask for this court to tell him, give her her social security card. And if he doesn't have it, doesn't have it, but.
I agree. If you have it, turn it over. If you don't have it, inform counsel that you don't have it, so it can be.
And again, he
She
doesn't
can
have
get
it.
She can go on the website and get a license card. Social Security has a website, so you can get a replacement pretty easily, which I'm assuming she knows what the number is. But he should have no reason to have it either. If he has it, he needs to turn it over. Okay, so what else can we do?
Well, beyond that, you're beyond the issues of property, which I think generally are probably something that can be a matter for the divorce court. We've discussed the possibility, I don't know if the state's actually said this, but this is a cross-filing situation. And one of the possibilities we discussed was a 90-day continuance. Ms. Searles is agreeable to that. It looks like I'm seeing filling the paperwork out, so it looks like we're all in agreement that we can do a 90-day continuance.
Okay, so I think that takes us into January. '23rd of January.
Strangely, I have a jury trial that day. I was going to say that might take us far enough out that we don't have that problem. But the surrounding days, well, the 26th I have a jury trial as well, but the 30th I'm available.
Well, that's what we're going to discuss. State's position on costs.
We would want one court cost.
Ms. Searles is not currently employed. Mr. Searles, I believe, is. So if he's willing to take that on, that may be a possibility.
If the court assesses court costs for him, he's not going to pay her court costs.
Well, it's one set somewhere.
The state asked for it.
I believe she has been employed for like the last couple of months. He's indicated that he's still willing to pay.
So we got to pay her $125.
Probably in the divorce, Your Honor.
Yeah, okay. All right, so I'll put it down for the 30th. I think, is that what we agreed to, the 30th?
That's correct, Your Honor.
And it'll be dismissed then without appearance. That's worth $125. Dismissed without appearance if there's no further problems and the costs are paid on Mr. Searles.
Thank you, Your Honor.
When is it? When we come back on?
January 30th.
January 30th. But they don't have to appear if there's problems or the costs are there.
Take your honor.
You know what?
Yeah. It's 2026.
I picked 25.
That's what I was gonna say. That would be 3 years, exactly. Because mine's January 30th, 2029. I don't know, so many times. Like really, actually.
On the private side of matters, there would be cases on the bridges.
Believe me, I'm anticipating that.
That's not a picture. That was from like 3 years ago.
State of Ohio versus Dylan Adair, case number CRP 25679.
Mr. Stratton's case.
Yes. Of course, he's not here today. I spoke with Nikki. Yeah, I forgot her last name there. This morning, she was headed over there this morning, and she was
trying long-term placements.
Yeah, she actually was talking about RRS as possible placement for him. So she's going. So we're just going to work on doing that. If we can set it back maybe a week, we'll probably have some info on that. So
We probably should, I think, set it for Monday, because it's my understanding they can only keep him for a limited period of time, and then he's got to either go back to the jail or get released. So.
yeah, seems like they were going to have a planned meeting this morning over exactly what they're going to do. But she said RRS is where she, and I know that, Jeremy, you have beds available, right? Yeah, so.
Well, let's put it on the docket. I don't know if you're available, but if
I'll be
not,
here.
we can do it by teleconference, telephone, but probably if it's like the previous case that they were involved with, all we need to do is an entry confirming that they were permitted to go to that facility for treatment.
I'll be here Monday.
Okay.
Yeah.
So let's put it on the docket for Monday, the
Okay.
20th. It'll be a pre-trial.
State of Ohio versus Evan Davis, case number CRP 25202.
Mr. Stratton's case.
Which one is this?
That is a pre-trial. He said Lawrence County Recovery. Good report, good screens.
You already got an additional report for you here.
Okay.
That talks a little bit more about some other stuff. It has the couples, what is it called?
Couples therapy counseling.
Yeah, couples therapy counseling.
Okay.
Yeah, sorry, Mr. Field, I should show it to you first. We were talking about dismissing this once he completed his counseling, and Where's the CPS case at?
Lawrence County.
I mean, what's the status of it?
Tuesday, we should be wrapping up, I hope.
Tuesday, this coming Tuesday? So it sounds like the CPS case is gonna wrap up probably this Tuesday, so. And those were the two things that he needed to do to get his dismissed.
He's still inpatient, you know?
Yep.
What's the state position?
Well, we're pleased that they're making progress. We want to go through the completion of everything. So we'd like to come back again, and I don't know, maybe a month from now, is he still going to be in treatment at that time?
Well, it's kind of, he's doing really well, so it kind of depends on how Tuesday goes and then further.
We can come back sooner than I'll check. He's working now, I take it?
Yep.
Okay. Is, Ms. Maynard here today? Has the state any contact with her?
Yes, she says everything's going well. She's ready for the charges to be dismissed. And she indicated that he would bring verification of the counseling today, which I guess he has. So we want to hear what the Children's Services case, what the outcome of that is.
Okay, so Children's Services is also involved.
Yeah, and then it sounds to me like once that's done, then that will be the determining factor in the completion of his residential treatment.
Yep.
So I guess we can come back fairly soon.
How about the 3rd of November?
I'm not available the 3rd.
7th or 10th?
The 7th.
November 7th will be the next hearing.
Yeah.
Thank you, Your Honor.
You are.
State of Ohio, Kelly Green, case number CRG 49489.
Mr. Stratton's case.
So, yeah, that's all right. We'll look at you. Your Honor, we just need to reset this for another pre-trial, maybe on the 6th that we had just set.
I didn't hear.
We just need to reset it for another pre-trial, this case.
And what date did you suggest?
The 6th?
7th? November 7th.
November 7th, I'm sorry.
That's a Friday. All right. This request case November 7th.
All right, there you go.
Is there any discovery issues we need to?
Well,
You have,
well, I'll have to get discovery, yes, that's the reason why I want to reset. But, well, everybody, we need to get whatever they have, so, but you go take care of your personal matters, okay? All right.
State of Ohio recalls Mickey Wilson, case number CRA 25537.
All right. Mr. Stratton represents Mr. Wilson. He had been out of pocket for a little over, not quite a month. This hearing is September 19th by my record, so he's here today. And it looks like he's at Lawrence County Recovery.
Yes, Your Honor, he was, I think, initially ordered to go RRS. He had some major family issues that we would not like to, if you want us to approach, we'll discuss that, but, and he's just getting things back together right now, and so as his bond be continued or his bond be reinstated, the warrant withdrawn, and him put back on the path that he was on.
And he's, is he inpatient now, or what's his, how is he receiving services?
He's outpatient right now.
Okay. What's the state's position on it? It's a felony position.
Well, I suppose that there's been adequate consideration of whether it ought to be residential or outpatient at this point?
We actually recommended inpatient.
Well, that maybe needs some discussion.
Yeah, because he was ordered initially to get an RRS, and I'm told he left through.
Your Honor, may we approach?
Yeah.
See how it goes. Just let the court know where you're living at, your current address.
1505 Lawrence Street Apartments, apartment 2A.
So, Your Honor, I asked that we try outpatient, and he understands if he doesn't do well in outpatient, that inpatient would be where he would go.
Okay, we'll try it for a couple weeks. Set the next hearing if you're available the 31st.
Yes. Yeah.
Okay, October 31st, 2 weeks from today. You want to stay outpatient, you need to get a report.
All right.
That's a preliminary hearing. 10 o'clock.
All right, thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
Pretty good.
State of Ohio, Travis Cement. Case number CRA 2539, CRA 25311, A and B, CRA 24344, CRA 23380.
All right, Mr. Mintz, teleconference, his attorney, Mr. Cyrus, here in person. Yes. Get the report from Shawnee. Okay, it's a good report.
1031. Oh, okay, 1031.
Your Honor, a very positive report. We have quite a few different things pending here at this point. I'm not sure what the state's pleasure or the court's pleasure at this point is.
What's the state's position?
No, I'm glad to see the word impressed in there. That means it's really doing good. We've had him for one thing or another for quite some time. And so the charges that we have, the most current charges involve a possession charge and the paraphernalia charge. And he'd already pled guilty to some other charges. Well, we want him to continue on and be successful. Maybe it's gonna stick this time.
Let's hope.
So we're okay with continuing again and,
What sort of a time frame would the court be looking at, Your Honor?
What?
Okay, so, here we go. November 17 is a month and I'm available.
November 17th, Mr. Bennett will be your next hearing. Good job. Keep working at it. Don't quit.
Here pretty soon, I'm going to be looking to get out of line and get a place again. Is that something, you know, just going to bring that up?
Well, Your Honor, my guess on that, he doesn't have a monitor on at this point, so my understanding, my guess would be that the court's position would be that whatever the treatment center says he's able to do and ready to do is when you'd like him to do that.
Correct. I agree. So whenever they say you're ready for outpatient, then I'll be on board with that.
I'll get with his clinical team and
Okay, talk to your treatment team. Your next hearing is in a month, November 17th.
All right.
Thank you.
thank you, Your Honor.
State of Ohio versus Garrett Posey, case number CRB 25546.
Your Honor, Mr. Hosey contacted me a couple moments ago and said he was on his way here, but he's not here yet.
Will you call Franklin tonight?
Thank you.
State of Ohio versus Austin Hawthorne, case number CRA 2357, CRB 2358, CRB 27020-893.
Mr. Hawthorne is here, and Mr. Morford is here, and Ms. Klein. He's for the counseling center. Yes.
Good.
Okay, he's completed with the counseling center.
That's correct, Your Honor.
He's under also the supervision of common employees. In one case here, I believe that he has, is actually completed 2843, it's completed. Well, actually, we can do both. Congratulations, I'm gonna complete all your cases here. I don't know if you're completed with common pleas, but you won't have to come back here anymore unless you just want to visit, which is welcome. This is the best you've done since I've known you, and it's been a while. So congratulations, keep it up, keep working at it.
So this means my bonds be released?
Your bond's released.
Do I go to the sheriff's office for that?
No, you don't have to. Did you post a cash bond?
Yes, I did.
See the clerk.
Yes, sir.
Nice.
File or petition number 24-6. He would be pleading to one count of retail fraud, third degree, in file 24-3, which is the one that we have trial set for. It would be a misdemeanor count 1 of possession of a weapon on school property. In file or petition number 25-5, count 2, breaking and entering illegal entry, which is a misdemeanor, and all of the other charges and files would be dismissed.
Ms. Bruker, is that an accurate statement?
That is correct, and I sent a plea sheet to the court and to Mr. Brown that outlined that.
All right. Arian and Mr. Hesselmeyer, you've heard what the attorneys have said. Is that what you want to do today?
Yes, Your Honor.
Mr. Hesselmeyer, does that meet with your approval as well?
Yes, Your Honor.
All right. There are, if my memory serves right, there are approximately 6 petitions pending against Arian
believe it was 7, sir.
Yep, you're absolutely correct. Thank you. That's why I was checking to see the sheet that I have. So there are 7 petitions pending, which include charges of runaway in petitions 1 and 2. Petition 24-3 is the possession of weapons charge. Petition 4 is retail fraud. Petition 5 involves police officer resisting and obstructing and breaking and entering. Petition 6 involves retail fraud. Petition 7 is retail fraud, receiving and concealing and youth tobacco act violations. All of those other petitions that were not placed on the record today would be dismissed. Is that what you want to have happen, Arian?
Yes, Your Honor.
All right. In order to do that, you would end up having to plead what we would typically call guilty or admit responsibility, and you would not have a trial. Specifically, we have a trial coming up, I believe, next week, but you would not have a trial, and all of these cases would be resolved by you telling me what you did that was wrong. Do you understand that?
Yes, Your Honor.
All right. If you wanted to have a trial, these would be the rights that you would have at that trial that you're going to be giving up. You'd have the right to have a trial in front of a judge or a jury. You'd have the right to be represented by an attorney. You'd have the right to see, hear, and question all of the witnesses. You could get an order from the court requiring witnesses to appear and testify on your behalf. You could testify if you wanted to, or you could remain silent, and that silence could not be used against you. At a trial, you'd be presumed innocent until proven guilty beyond a reasonable doubt, and that burden of proof would always be with the prosecution. Finally, at a trial, you'd have an automatic right to appeal any error. However, if you enter a plea, you'd be limited to asking the court for permission to appeal. Do you understand all of those rights?
Yes, Your Honor.
Do you have any questions about any of those rights?
No, Your Honor.
Do you know what will happen if you enter a plea today as to what will happen to all of those rights?
Yes, Your Honor.
What will happen to the rights if you enter a plea?
They will be given up, Your Honor.
All right. Mr. Hesselmeyer, do you have any questions about any of those rights that I've just given to your son?
No, Your Honor.
All right. Arian, I'm going to ask you to raise your right hand so I can swear you in and take some testimony from you. Do you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right. Let me flip to the appropriate petitions. So as to petition 24-3, that alleges in honor about October the 16th of 2024 in Otsego County that you committed the offense of possessing a weapon in a weapons-free school zone, in that you possessed a BB gun within the Gaylord High School. Is that what happened?
Yes, Your Honor.
Tell me about the BB gun. Where'd you get it from? What kind of BB gun was it?
It was a hand airsoft toy, like a small little one. And I got it, I think, for my birthday a little bit prior, like a year or two before.
And where did you have it in school?
I had it in my book bag.
All right. And that was at the Gaylord High School here in Gaylord, Michigan?
Yes, Your Honor.
All right. As to that factual basis, Ms. Brucker or Mr. Brown, any additional questions?
No, Your Honor.
No, Your Honor.
All right. As to petition 24-5, and count 2, which is illegal entry, that alleges in honor about November the 7th of 2024 in Otsego County that you did commit the offense of illegal entry by entering with or without breaking a certain building or structure that is a restaurant located at 900 South Otsego Avenue, whether occupied or unoccupied, without first obtaining permission to enter from the owners or the occupants. What did you do on that date to enter a restaurant without the owner's permission?
I simply just walked into the opening, Your Honor.
What restaurant are we talking about?
Gobblers, I think it was called, Your Honor.
That's the old Gobblers building on Wisconsin Avenue in Gaylord.
Mm-hmm.
The one that's shaped like an old A&W root beer stand. You probably don't have any idea what I'm talking about, do you? All right. So you went in there. Did you have any permission to go in there at the time that you went in?
No, Your Honor.
All right. As to factual basis, Ms. Bruker or Mr. Brown, any additional questions?
No, Your Honor.
Oh, Your Honor.
All right. And then as to file 24-6, petition number 6, the allegation there is in honor about November the 7th of 2024. You committed the offense of retail fraud in the 3rd degree, and that while Jay's was open to the public, you did steal property of the store that was offered for sale at a price of less than $200. What did you do to do that violation?
I stole a BB gun.
And which store was that at?
Jay's.
The Jay's here in Gaylord?
Yes, Your Honor.
All right. And did you go into the store while it was open?
Yes, Your Honor.
And where was the BB gun inside the store when you took it?
On the BB gun rack, I don't really know how to answer that one, Your Honor.
All right. So it's inside the store, and was the BB gun for sale at the time that you took it?
Yes, Your Honor.
And did you leave the store without paying for the BB gun?
Yes, Your Honor.
And did you intend to steal the BB gun?
Yes, Your Honor.
And was the price of the BB gun less than $200?
I do not know, Your Honor, but I'm guessing yes.
You believe so? All right. Ms. Bruker and Mr. Brown, any factual basis questions as to that?
No, Your Honor.
No, Your Honor.
All right. Mr. Hesselmeyer, you've heard what your son has said. Do you agree with his statements as to each of those pleas?
Yes, Your Honor.
All right. Are either counsel aware of any promises, threats, or inducements that were not stated on the record?
No, Your Honor.
No, Your
Do
Honor.
you believe I've complied with the court rule as to taking of pleas for minors in these types of cases?
Yes, Your Honor.
Yes, Your Honor.
All right. I do find that Arian has given me a proper plea as to each of these cases. I do believe that the factual basis has been met as to possession of a BB gun within the Gaylord High School, that there was retail fraud from Jay's by the stealing of a BB gun, and also that there was an illegal entry at the Gobbler's restaurant. And I believe he's made those pleas knowingly, intelligently, and voluntarily by his answers to the questions that I asked of him, and I will accept each of the pleas. We will cancel the jury trial now set for next week. And we will set these matters for a dispositional hearing after there's a recommendation made and a pre-sentence investigation made. Does the juvenile department need any additional information or any additional findings?
Your Honor, I would ask that he be placed on formal calendar probation and on community-based services. At this time, Amber McLeod will be overseeing his case. I would like to add in a couple recommendations, or even ask that the court order that Mr. Hesselmeyer allow us to talk to Arian. There are some assessments that need to be conducted, and they will just be conversation between the juvenile officer or myself and Arian, as it's information based on his past and presence. So I just ask that the court order that they be compliant.
All right. Mr. Hesselmeyer, do you have any objection to those requests?
I'm not exactly sure what she's asking of me there.
She's asking to be allowed that the juvenile department, as part of their investigation, to make recommendations for sentencing and for their record keeping, that she be allowed to speak with Arian.
She's allowed
That's
to
a
speak.
normal part of the process.
Yeah, okay.
All right. All right. We will place Arian on the formal calendar with community-based services. I will order Arian to comply with the process for completing the probation recommendations for sentencing. And we will continue all other orders of the court at this time. Mr. Brown, is there anything else from your perspective?
There's nothing else, Your Honor, currently. I would state for the record, I don't know how this is going to work out. I believe Arian is living in a different county at this time. So I don't know if we are going to be monitoring this the entire time, or if this is going to be essentially sent down, I believe it's Genesee for supervision.
Well, and I don't know that yet because I haven't gotten a recommendation. So that's one of the things that I'll be looking for as part of that recommendation. And I certainly take requests from Mr. Brown or Mr. Hesselmeyer in the future as to that. But for now, I need to have the recommendations done so we can set the matter for disposition. Ms. Bruker, is there anything else from your perspective?
No, Your Honor.
Anything else from probation?
No, I just would like it noted or on record that we will talk to Arian by phone, or I may even schedule a Zoom meeting to be held with him. So I will contact Mr. Hesselmeyer within the next couple days to figure out what's going to work best for that family.
All right. Thank you very much. Mr. Hesselmeyer, anything from your perspective?
Yes, I just wanted to let everyone know that Arian has not gotten in any trouble since he's been here. He has completely changed his way and turned himself over, and that he is now doing well in school. He's not having any outbursts or anger or anything like he had when he first got here with me. And I really want you guys to take that into consideration when evaluating, and that we're doing our best to meet any stipulations that your court will recommend. We'll do our best to make sure that we're there for all of this. We're going to get through it together is what I've been telling him from the get-go.
Good. Well, I'm pleased to hear that. I look forward to hearing what the recommendations are going to be, and look forward to hearing from yourself and from Arian as a part of that process. So that will be all for today. I simply ask Arian to continue to cooperate with the probation department so that we can have the dispositional hearing recommendations set forth quickly, and the court will send out a notice for when that dispositional hearing is. Thank you all very much. That's all.
Good luck.
Congratulations.
Thank you.
Don't give up though. You gotta keep working with it.
Just like to have a contingency if all possible.
Okay. What's the state's position on
Your Honor, it's my understanding that Mr. May's father and stepmother, who were here the other day, have obtained emergency custody of the child. At least that's what I've been told. And we had also made an inquiry to Children's Services, and I actually have a report from them as well, although this was done, I think, well, it's yesterday, so I don't know if they know that the temporary emergency custody has happened or not, but I can present a copy of this to the court as well, but I don't think I have a copy of it right now. In fact, I can make myself a copy.
Well, I was concerned about the fear of children, minor children. Okay, so it sounds like Children's Services is going to be involved in recommending some counseling services. So I think that's a good idea. And it sounds like the children are safe now. That was my main concern.
Absolutely.
So do you want to come back? Well, give me an idea, sir, when you think you'd have Mr. Dwyer engaged, when you want to come back for a hearing?
He told me he would speak with me next week. Obviously, the sooner the better. My chief complaint right now is I'm in kind of a financial situation with this monitor. I'm on a total home confinement.
Modified, where do you work?
All over the tri-state. I serve a 25-mile radius from Davidson Hill, typically.
Do you work for someone or yourself?
I own my very small electric shop.
Okay. I'm going to modify, I'll send out a modification to allow you to work. Well, I guess I should hear from the state. Do you have a?
I don't mean to interrupt, if I kind of continue just a little bit further. We take some really atypical calls. We do outage work, we do emergencies, we do stuff that's 24 hours a day. I don't keep per se a standard 7 to 7 or 8 to 8 schedule. If we get a call at midnight and somebody's in, need of work, we go. So just with that in mind, if you'd work with me, I'd appreciate it. I'll cooperate, whatever you guys want to do.
Well, my understanding was one of the concerns was you being around a certain person, but now I've been informed that that person is with you, wants to be with you. This is an ex-wife, mother of these children.
The reason that the probation violation was filed was because I don't know whether there was some other reason for law enforcement or Mr. Major to contact Mr. May, but the victim on that case, that assault case from several months ago, was with him at the time.
But was she with him voluntarily or involuntarily?
Well, who knows? She's here today.
Okay, where is, okay, ma'am, would you come up and talk to the prosecutors, please? Yeah, talk with him. I need to know what the position is with regard to staying away from Mr. May. He needs to stay away from me.
So they're limited from the domestic violence, no contact.
You need to talk to your attorney. And she says that they've got children together, and so that caused this complication in which they were in the same place, but apparently not for romantic reasons or out of force. But I think she agrees that keeping them separated still at this point is a good idea. Now, as far as the GPS monitor, we appreciate the fact that Mr. May works, but it just seems like all these different things keep coming up that we're afraid there's going to be some real bad problems going to arise, and we're trying to avoid that. This is a probation violation, and I think Mr. Major was the one that filed that probation violation, so maybe as far as whether the GPS monitor is appropriate at this time might be include his input as well.
Well, could it be fixed if we So are you two are not living in the same location?
No,
Okay.
we're no
So
longer in the same location.
if we get your location and order him not to go in that area, is that a good idea? And allow him to go to work, so he can go everywhere else but where you are.
That's fine if that's what needs to be done.
Well, I just don't want there to, I don't want you to get hurt, or to be some allegation that there was a problem, or at least that's a temporary solution until we can come back to court and get a more permanent solution, and then he can go to work.
No, you're right. I understand. And at the time, whenever the protection order was issued at first, I was confused on the different types of orders, and where it said subject to our parenting order, things got a little cloudy for me. Is obviously not staying, but they got cloudy for me. And where there was an emergency situation, the best thing at the time was, in order for the kids to have a place to stay, was there. I mean, there was nobody else to take them to, and I had to make sure they were safe. So
Well, now I guess I'm informed, there's a temporary order there with the grandparents.
they've been placed with their grandparents, yes.
So
So
I'm
now-
assuming they're safe,
Yes.
and I'm only talking about a week here, so
Right.
are you okay and state okay if I modify the order for his GPS that he not be homebound, he'd be allowed to work, but he's not allowed to go around her, and she's gonna give us an address where that is.
Yeah.
Is it still 2301 Broadway Street?
Does that work for you, sir? That way you can go to work. And then we'll come back and say a week.
I'm gonna do whatever you tell me, but I got another, just an alternative. I'll give her the residence. As far as this child order, there is so much ambiguity in this wording, both on the Kentucky side and over here. No contact other than children. It's all about the children at this point.
Okay. Well,
So I don't want her to be displaced.
That's gonna come back into effect. I'm only talking about a week.
Whatever you tell me, Judge, that's what I'm gonna do.
And then we'll figure out, I'm not gonna keep you away from your kids permanently, but I'm gonna say, let's do this for a week. You go back to work, we'll come back in another week. Hopefully get your lawyer here then and figure out how we're gonna go forward. So, my order is gonna be to modify the GPS that you're not homebound, you can go to work, but you can't go around her.
Okay.
We're gonna get an address from her where she's gonna be.
Okay. Sure.
Then let's come back on the 24th. You need to get in touch with Mr. Delauder's office, tell him that's when it's set for the next hearing. And he can even appear by teleconference, or he's gonna represent you, he can have some conversations with Mr. Heel prior to that hearing. Okay, does that work? Do we have an address for her where she's gonna be?
Yes. We've given it to the probation office, and we can provide it to whomever.
Miss
needs
you
it.
for the intro.
Yeah.
Our address will be on the entry.
Let's put it on the entry, I'm not gonna put it out on YouTube.
I can put a different address for myself, if that would be easier.
Was the address where you're staying now her address?
I can go anywhere. I can go to a relative's. I've got
Has it been
options.
the same address? I mean, that's what I was assuming he was at someplace else.
No, I'm someplace else. He is in the same.
She had brought the kids that we were out there with the children that day that,
I have taken the kids out there, but he is remaining there, and I have since gone
I'd rather go than,
to Kentucky. But whatever is easier, like I'm good. We are staying away and maintaining the order.
Okay,
He's in this spot.
you want to stay at the address you are now? Is that correct?
Yes, that's fine with me.
Okay, so you'll be ordered not to go to the address where she is now. That's just for a week. We'll come back in a week next Friday and revisit this. That way you can go to work.
Your Honor, there's another charge pending that was scheduled for November 3rd.
Let's move it to next Friday also. Put everything next Friday. All right, Mr. Cooper, can you talk with Mr. May and then coordinate? I guess he won't have to go to adult.
I don't know, I'll send the entry down and I'll contact him and let him know if he needs to get in.
Okay. All right, so make sure Mr. Cooper has a way to get in touch with you later this afternoon if he needs to.
Yes, sir.
Any questions?
If my mom or my dad calls and says my kid's chopped the finger off, can we go to the ER? I mean, is that about the children?
Yeah, what are,
You're just ordered to stay away from her, not kids.
Okay. Thank you. Thanks, sir.
October 24th is the next hearing.
Yes, sir.
Yes. It's not, yeah.
At what time, sir? Oh, I'm sorry. 10? Thank you.
All right, I'm going to need to take a break. There's a request for a search warrant. I need to meet with police officers about that, so we'll take a little recess while I do that, and we'll come back. I'll see them in chambers. All I need is to see what.
For us, or? Sam, are they searching me? Okay.
Yes.
I'm gonna do that now or else I'll forget.
Yeah, you better.
I'm like, I'll do that or else I will forget. Which, I think easy too.
Is it? Between profile and profile.
State of Ohio versus Larry Brumfield at Lawrence County Jail. Case number CRB 25658. And Derek Lockhart is on deck.
Yep. We'll go, when the jail comes up, we'll go to them, but they're not there.
State of Ohio recalls Corey Brewer, case number TRC 251869.
Anyone have court case, be in courtroom.
Okay, so in this case, I'm going to try to get a hold of the other parties involved in this wreck, to see if there's any restitution issues.
Yes, and we did that, and what did that guy say?
And I was present when the phone call was made. It's my understanding he owns his own body shop. He does not want to bother with restitution. Doesn't have receipts apparently, but I didn't speak to him, but I did hear the Jasmine's end of the conversation.
Okay, we did speak with, whoever that fellow's name is, Jeremy or something, and he does not request any restitution.
Okay. All right, so we go ahead and do the sentencing
Yes, sir.
today. And I think I asked you to make a record, you have a right to make allocution, is the fancy word for it, make a statement to the court if you want. Do you have anything you want to say?
No, Your Honor.
All right. I'll impose a $375 fine, that was what was recommended, court costs. 6-month license suspension, that started the day of the incident. So you've got some time in on that. 20 days in jail suspended, 30 hours community service, 2 years of level 4 probation. Dip school.
Yes, sir.
Driver intervention program, so that stands for 3-day school, you have to do that. And you can go to any program that's approved by the state of Ohio, there is one here in Lawrence County. You don't have to go to that one, you can go, because there's some others that are cheaper. You can go to anyone that's approved by the state. But you go to one outside the county, you gotta make sure they notify the court that you attended and completed. I'll set his review hearing for April 24th of next year, so it gives you a long time to get all this stuff done. If you get it done, you don't have to come to hearing. The hearing is to check and make sure you did what you were ordered to do. It's at 9 a.m. on April 24th. I'll dismiss the B case that was agreed that it would be dismissed. He needs to see Mr. Cooper about his probation. And then he's free to go.
Yeah, they'll send
Any questions?
it. Your Honor. We're good. Thank you, Judge.
You're welcome. Good. Okay, so now we're back at the jail for the next hearing.
State of Ohio versus Larry Brumfield, Lawrence County Jail, case number CRB 25658. Darius Lockhart on the
Are you Larry Brumfield?
Yes, sir.
Can you hear me okay, Mr. Brumfield?
Excuse me?
Can you hear me?
Yes.
I'm Judge Capper. This is what's called an arraignment hearing for you. You have a right to remain silent. You don't have to say anything. If you do make statements, it's being recorded and it's on the record. It can be used against you. You have a right to have an attorney, to have one appointed if you can't afford one, to have bail, to make the state of Ohio prove the charge looks like it's this one against you beyond a reasonable doubt. You understand those rights?
Yes, sir.
The charge against you is driving under the influence of alcohol or drugs, and it's charged, it says it in one. So the state's alleging that on October the 14th of this year in Union Township, you operated a vehicle while being under the influence of drugs or alcohol, and that you've got a prior conviction for operating a vehicle intoxicated. So this would be a second offense. On a second offense, the maximum penalty is 6 months in jail, $1,625 fine, 5-year license suspension. The minimum penalty is 10 days in jail, $525 fine, and a 1-year license suspension. If the vehicle you were operating was titled to you, it's also mandatory that it be impounded for a period of 90 days if you're found guilty. Do you understand that charge and the possible penalties?
Yes, sir.
How do you wish to plead to the charge?
Guilty.
If you enter a guilty plea, you're admitting the charge is true, giving up your rights to have a trial, to have a lawyer, and there is a mandatory jail sentence on this. Do you understand that?
Yes, Your Honor.
Is that what you want to do? You want to enter a guilty plea?
Yes.
All right. I'll accept your guilty plea. I'll need a statement of facts on this because I don't really have much info on the facts of what led to the charge.
And Your Honor, I have a narrative by Officer Landon Johnson from Chesapeake Police Department, and he says that on Tuesday, October 14th, 2025, at approximately 11:15 hours, I, Patrolman Johnson, was on routine patrol traveling northbound on the State Route 7 to 52 bypass when I observed a black Chevrolet pickup truck that appeared to have expired registration and was committing additional minor traffic violations. Based on these observations, I activated my emergency overhead lights and initiated a traffic stop. Upon approaching the vehicle, I observed that the registration sticker on the rear license plate, while valid, was not correctly affixed, making it unreadable from a distance during my initial observation. I made contact with the driver, who identified himself as Larry Brumfield, by presenting a state-issued identification card. Brumfield stated that he did not possess a valid driver's license and was unable to provide proof of vehicle insurance or personal injury insurance. I asked Brumfield to exit the vehicle and walk to the rear of the truck for further questioning. Upon contact, I observed that Brumfield had constricted pupils, and slight body tremors, both of which are physical indicators commonly associated with methamphetamine when combined with fentanyl use. Based on my training and experience, I asked Brumfield if there was any illegal substances in the vehicle, and he admitted there was a glass bowl inside his lunchbox, but denied possession of any additional contraband. When I asked when he last used any illegal substances, Brumfield voluntarily stated that he had smoked methamphetamine earlier that day before leaving for work. Based on Brumfield's admission to my observations, I proceeded to conduct standardized field sobriety tests to assess his level of impairment. During the horizontal gaze nystagmus test, I observed a lack of smooth pursuit and slight twitching, though no distinct signs of nystagmus were present. His pupils remained constricted but equal in size. I then conducted the modified Romberg balance test. Brumfield was unable to maintain the proper stance as instructed, frequently placing his hands in his pockets or behind his back. When asked to stop the test based on his own perception of the passage of time, Brumfield demonstrated an accelerated perception and failed to follow the instructions properly. During the walk-a-turn test, Brumfield followed instructions well, but walked at a slightly accelerated pace and continued to exhibit body tremors. During the one-leg stand test, Brumfield complied with the instructions, but counted noticeably fast and showed ongoing tremors. Finally, during the finger-to-nose test, Brumfield continued to show body tremors, a lack of focus, and difficulty maintaining the correct starting position. Based on the totality of my observations, Brumfield's own admission and recent methamphetamine use, and his performance on the field sobriety tests, I had probable cause to believe he was operating a motor vehicle while under the influence of a controlled substance. At that time, I placed Larry Brumfield under arrest for operating a vehicle under the influence. He was then transported to the Lawrence County Jail without incident for further processing. Larry Brumfield was cited for possession of drug paraphernalia, no valid driver's license, and no valid insurance.
All right, Mr. Brumfield, do you have any statement or explanation you wish to give the court before I send it?
No.
I have a Huntington address for you, is that right?
Yeah,
In the officer's report, he says you were working. Where do you work?
I'm working, I work for myself right now.
What do you do?
I remodel houses, remodel, rental properties.
Do you do that for someone, or how do you
Yeah.
get hired?
Yeah, John.
Who do you do that for?
Roscoe Middleton. And it would, I have several guys work for.
Okay. Do you have a West Virginia medical card?
Yes, I'm Medicaid.
Have you ever been to treatment before?
I have.
Where'd you go?
I went to Huntington Comprehensive Treatment Center.
So you're in treatment now. You've been in treatment.
Yes.
Are you getting any medically assisted treatment? Are you getting any prescriptions that are supposed to help you with an addiction problem?
I don't have those.
Okay. Currently you are?
Yes.
How many milligrams a day?
110.
Okay. Quite a bit. So you haven't had any for a few days?
No.
You having withdrawal?
Yes.
Well, I'd like to, in my experience, and so you're going to Ultimate, you're getting the methadone from Ultimate Treatment Center, right? In Huntington?
Yes. Yes.
The problem I have with them is they never try to get anybody off methadone. I mean, they'll give it to you, as long as you keep showing up and paying them, they'll give it to you without any counseling or any effort to get you clean. So it just keeps you hooked and dependent on them. So I'd like to see you go a different direction. The problem's gonna be, you're gonna have to, well, we'll see where we go with this, but, you've got some mandatory jail time. Was this a second offense? Was there a record of him having a prior?
We did not receive a record, and so we could, oh, here we go, wait a minute, maybe we do have a record. Spoke too soon. 2018 Mason County Sheriff's Office. Yeah, he was found guilty. I assume that is a court record. Wait a minute, here's one that says dismissed. Oh, okay. It doesn't have any prior ODI. Okay. But where is the? I think
This one in West Virginia.
one prior ODI conviction. Okay, yeah, there was one in Mason County in 2018, so this is a second.
All right. So this should be, the sentencing will be under a second offense. I'll impose a $525 fine. Or you pay the court costs. You're gonna get a 1-year license suspension, and it started on well, it started today, actually. The 17th, October 17th. So actually 1 year.
Keep it in mind.
I'll sentence you to 30 days in jail, suspend 20, give you credit for 3 days. I'm going to put you on probation for 2 years of level 4 probation. So he's doing his jail now. I'm going to also, I have to require on a second offense for you to get substance use counseling. But I'm not in favor of you going to Ultimate Treatment Center because I don't think that's a joke, what they do. So I'm going to refer you to well, you're at 20th Street. Is that the correct address? 923 20th Street?
Yes.
I'm going to refer you, you can either go to OVP, which I believe is at 6th Avenue and 20th Street, or you can go to ProAct, which is at 9th Avenue and 20th Street in Huntington. Both you can walk in and get treatment.
Okay.
And then I want you to come back to court, because what's going to happen is I'm going to monitor your treatment, and they'll give me reports as to what you're doing. Now, we can turn this into a positive. You need to get clean and get off methamphetamine. Over the long haul, it's going to take a toll on you.
Okay.
Yeah. You do that for very long. I mean, 3 years, your wage 20 years. You use it for 3 years. I mean, from what I see. And if you get any drugs off the street, you don't know that you're not getting fentanyl. That's the other problem.
Right.
It's like playing Russian roulette. You get any drugs off the street, it can have stuff in it that you don't know. And the the most dangerous drug that's out there right now is fentanyl.
Yeah, I agree.
So those two places can help you. They're very good. They're medically based. And you can walk in and tell them that you're with this court, that I sent you there, and then they'll give you reports as to your treatment, which I'm going to monitor. And you're going to come back for your first hearing for a review. Let's make it 1 month, so that's November 17th.
Okay.
Do you know where the court's located in Chesapeake?
Yes.
Okay, so that's, you gotta be here at 9 a.m., November 17th, for your first review hearing. With a report.
Okay.
If you don't show up, then I'll have to issue a warrant for you, and when you get arrested, you have to do the jail time.
Okay.
The additional jail time.
Right.
He was, but, there was no test, so it doesn't start until,
Today.
well, his jail time does, but on his license suspension doesn't start until today.
Okay, jail time starts.
Yeah,
Today?
giving him credit. No, he gets credit for 3 days,
I have to put in the beginning jail day.
14. That's when you start. Okay, any questions, Mr. Brumfield?
No, Your Honor.
Okay, that's all. Good luck.
All right, thank you.
State of Ohio versus Derek Lockhart, case number CRB 25660 and CRA 25659.
Answer, you're Derek Lockhart.
Sir,
Mr. Lockhart, I've got to go over your rights with you. You have a right to remain silent. You don't have to say anything. If you do make statements, though, it's on the record. It can be used against you. You have the right to have an attorney, to have one appointed if you can't afford one, to have bail, to make the state of Ohio prove the charges against you beyond a reasonable doubt. Do you understand those things?
Yes, sir.
There's 2 charges. 659 is a domestic violence charge, 25659. It alleges that on October 15, Union Township, you knowingly caused or tried to cause physical harm to Chelsea Lockhart, that she's a member of your family or lives in your household. And it's alleged that you got a 2 prior convictions, so that makes this a felony 3 because of the prior convictions. On a felony 3, the maximum penalty is 5 years in jail and a $8,000 fine. 660 is the other charge filed against you, 25660. It's a resisting arrest charge. It alleges October 15th, Union Township, you interfered with the lawful arrest of yourself. That's a 2nd degree misdemeanor. Maximum penalty is 90 days in jail, $750 fine. Do you understand that charge?
Yes, sir.
You had the money to hire a lawyer to represent you.
I don't have money to hire a lawyer.
Have you been working?
I'm sorry.
Have you been working? Do you have a job?
No, I've been staying home with the kids. I was supposed to work community social service all last week and didn't get through the baby's just there. I was sick.
I'll appoint Mr. Morford to represent you.
I'm sorry?
I'm going to appoint Mr. Morford to represent you. He's here in court, so he's going to be appointed as your lawyer. What's the state's position on bond for Mr. Lockhart?
Chelsea Lockhart.
So we're going to ask for a protection order, and we'd ask for $10,000 cash surety bond.
Is there any way at all I'll be able to over like by Monday I'll go to church?
What's the state's position on that?
Well, if he says he wants to go to treatment, that, of course, our intent's going to be to take this to the grand jury, but we'd be okay with him being assessed to go to treatment if it was a GPS monitor. and then he would waive the next time to the grand jury.
Okay, RRS says they have a bed. Problem I see is usually on Friday afternoons is the GPS monitor place. So what we could do is put it on the docket for Monday if you're here, Mr. Morford.
Yes, Judge.
And then if it hasn't happened, we can make the GPS monitor happen probably Monday. That means you're gonna be in jail. So you don't think you could post a $10,000 cash or surety bond, correct?
No, sir, I can't.
Okay. So what I'm gonna do, I'll set your bond at $10,000 OR. That means you can just sign a guarantee that you'll be in court as ordered. But I'm also gonna require a GPS monitor and treatment with RRS. Now, they have to assess you and agree to take you, that you're eligible for them to take. So if that doesn't happen, then they'll notify me. But assuming that they think you are eligible, I'll release you once the GPS monitor is placed. But from my past experience, I don't think it'll happen this afternoon. It'll probably be Monday. So I'm gonna put you back on the docket for Monday, October the 20th for preliminary hearing. Okay, do you have anything you want to say, Mr. Lockhart?
I will get hopefully what the preliminary hearing was at.
Yeah, that's the first hearing in a felony case. It's called a preliminary hearing. That's what we call it. And I'm setting it for Monday, but it's going to be more of a status conference to try to get you into treatment. That's probably not going to happen for them. It could happen today, but I doubt it. So just to make sure it does happen, I'm putting the case on for Monday at 10 a.m.
So I'm not getting up to that.
I would say not. You can if you get an ankle monitor replaced and RRS says they'll take you. I think they're going to take you. I don't think they're going to get an ankle monitor today. In case that you do get out, your attorney wants a cell number where he can reach you. Do you have a cell number where you can be reached?
Not really. She does, and my kid's grandma. They call her my kid's grandma.
Who's your kid's grandma?
Gina Gilmore.
Is that your mother-in-law or your mother?
It's my kid's grandma. It's like
well, most kids have two grandmothers, a paternal grandmother and a maternal grandmother. So
yes, sir.
Is this a paternal?
It's grandma. Well, my kid's kind of three grandmas.
Is this your mother or somebody else's mother?
It's somebody else's mother.
Okay, so I don't know if you want to talk about this, but you can give the number to Mr. Morford if you want.
Okay. So 740-961-1224.
Thank you, sir.
All right. All right. Well, if you're in treatment on Monday, they'll bring you. If you're not, if you're still in jail, I'll see you like this and we'll finalize getting you into treatment on Monday.
So to get out, before you get out, they have to have an ankle monitor?
Correct.
Okay. All right, thank you.
You're welcome.
State of Ohio versus Charles Ritchie, case number CRB 25662, CRB 25165, and Erica Williams is on that.
All right, sir, you're Charles Ritchie? Is that correct? You can hear me okay, Mr. Ritchie? You can't hear me? Okay. I'm sorry?
I have trouble hearing.
Okay, well, we gotta do this hearing today and get you arraigned. When did you come into the jail? October the 16th, it looks like. So if you want to wait till Monday, I can do it Monday and have you brought in person on Monday. And have you sit in the jail all weekend. You think that would help your hearing? If you sit in the jail all weekend? No. You think you can hear me now?
Yeah.
Okay. 2562, 25662 is the most recent case. And before I go over with you, let me go over your rights, which you've probably heard this many times. It's from a very famous case, Arizona versus Miranda. You have a right to remain silent. You have a right to have an attorney. You have a right to have an attorney appointed. If you say anything, it can be used against you. You have a right to bail. You have a right to make the state of Ohio prove the charges beyond a reasonable doubt. Do you understand those things?
Yes, sir.
Okay, the most recent charge is sexual imposition. The state's alleging that at Perry Township on October the 16th, you had sexual contact with April Rivera, in a way that was offensive to this other person or reckless in that regard and non-consensual, and that you've had a prior sexual imposition conviction. So this is charged as a first-degree misdemeanor. Maximum penalty is 6 months in jail, $1,000 fine. Do you understand that charge?
Yes, sir.
Then there's another charge earlier that looks like you never got served with. They attempted to serve you by mail and it got returned to sender. No such number. It was a Adams Avenue, Huntington, West Virginia address. Criminal damaging is that charge. It's case number 25165. It alleges March 1st, 2025, Perry Township, you created a risk of harm to property belonging to David Malone. That's a first-degree misdemeanor. Maximum penalty, 6 months in jail, $1,000 fine. And it looks like, I'm reading the affidavit, the property that was damaged was a vehicle. It was an automobile, is the allegation. Do you understand that? I'm sorry?
That was a joke, sir.
Okay, I'll take that as a not guilty plea. How do you plead to the sexual imposition charge?
Sir.
Okay, I'll enter a not guilty plea on that. So, you want a court-appointed lawyer?
Yes, sir.
Do you have a job? You're not working, are you?
No, I work on the grass, but I don't have no income. I've been trying to get SSI at each time. I've been trying to get housing for CAO, and they won't help me. David Malone died, sir. That's why I'm not being paid no rent.
I'm going to appoint Mr. Stratton to represent you.
All I get is food stamps and Medicaid, sir.
Okay, I'm appointing you a lawyer. And he's here in the courtroom, so he's heard the charges. He's present. He'll be representing you, at least through the preliminary hearing stage. And what's the state's position on bond?
I'm trying to get some help, sir, mental help.
Okay.
State would request a $10,000 cash assurance.
I lost the bond for a year ago, and I don't know what to do, sir.
I'm going to set a bond of $10,000 cash for surety for you. You think you can post a bond? Do you have any money with which you can post a bond?
I have no money to even bond out.
Okay, so we'll set your next hearing pretty quick then.
We'll probably set it for Monday if you want, Your Honor.
I don't know what we would do at that point. It's okay if we set it for Monday, but.
Okay, we'll set it for Monday, the 20th, with the end.
I think three was out the way.
I'll talk to him before then, Your Honor.
Your lawyer's gonna call down and talk to you, Mr. Stratton.
Yes.
Okay, that's all. You want to file, Mr. Stratton, you want to file?
Yes, Your Honor.
Okay, that's all.
Oh, we're asking for a protection order too, Your Honor. If that hasn't been discussed already.
Okay, there'll be a protection order with regards to the complaint parties.
That's fine. Thank you.
He's not gonna be out long anyway.
State of Ohio versus Erica Williams, case number CRB 25635.
Yes, Mr. Shires, please.
Yes, yes. Okay. Monday, at what time? 10. At 10. Okay, I'll make sure she's here. Okay.
Can you hear us, Ms. Williams?
Yes, sir.
Your Honor, and Ms. Williams, the state has made an offer that in return for a guilty plea on the charge that they would offer time served. Is that something you'd be interested in?
Yes, sir.
Is it something the court would approve?
Yes.
Then in that case, Your Honor, on that basis, we're going to enter a plea of guilty.
Do you agree with that, Ms. Williams?
Yes, sir.
Anything, you have a right to make a statement or explanation to the court if you want. You're not required to. Do you have anything you want to say?
No, thank you. Thank you for your time.
Okay. On the inducing panic, I'll impose a $100 fine court costs. She's been in jail since the 7th, so that's 10 days. I'll sentence her to 10 days in jail, which is completed now, so she can be released from jail. 2 years of level 5 probation. I'll order you to stay out of the KFC. Don't go back to the KFC.
They have like personal vendetta against me anyways. I used to work there, so I don't know, they just don't like me, so sorry about that. I had issues with my paycheck. It was like pretty much like a slave labor case, so like they had personal vendetta because my their manager would not like give my pay card to work for 2 months. Like I had to watch everybody else get paid while I work for nothing. So like I do have like a case against them for that. So like KFC's not paying. So sorry.
Thank you, ma'am.
Well,
Yeah.
your word not to go back there, that doesn't mean you can't pursue your case, but maybe you need a lawyer.
Right, yeah, I don't know.
Your next year, you have a review hearing April 24th of next year, 2026.
All right.
If you pay off your fine, court costs, you don't have to be here. That's the only thing you have.
All right, thank you so much.
Thank you, Your Honor.
Released from the jail here shortly.
All right, thank you.
You're welcome.
State of Ohio versus Jason Wilson, case number PRB 2218.
All right, you're Jason Wilson.
Yes, Your Honor.
Mr. Wilson, it looks like you got picked up on a warrant for failure to appear for a review hearing July 11th of 25.
Yes, Your Honor.
Do you admit or deny you missed your review hearing?
Yes, I talked to this month. I contacted probation. It was was Tuesday, and he had called me, and I asked him about doing community service there in Crown City, and I contacted the mayor, and I was going to do it this weekend and get put on the docket Monday, but did not make it there.
How'd you get arrested? What happened to cause you to get arrested?
I was in common police court for charges stemming from the same traffic stop back last year.
Oh, okay, and they checked and saw you had a warrant.
Yeah, I guess I'm assuming it's right.
Okay. Well, you've been at RRS for some counseling, and it says you're doing what you're supposed to do.
Yes, you are. I've been trying to do everything like I'm supposed to. You know, I made a mistake. My mother was passing, and I realized I made a mistake. I regret it. I'm trying to do the right thing.
So, and you're in common pleas, and they're gonna be sued. Did they require you to go to RRS too, or this court the only one that requires you?
Yeah, I guess it's pre-trial, they call it, part of the OR. I think that's what it is.
It's part of that work, Judge.
You're representing Mr. Morrison?
Yes, I represent him in common police court. We had a motion to suppress Wednesday, and he was arrested after the conclusion of that hearing, Judge.
Well, based on your serving some time in jail, I'm gonna come, and you're under the supervision of common pleas now, and they're requiring you to get a treatment. I'm not gonna supervise anymore. I'm gonna finish your case, say, because you had 3 days community service, I'll say the jail time completed that. So you can just answer to common pleas now. So I'm gonna release you.
Thank you, Your Honor.
You gotta do what common pleas
Hours to come. You
tell
service
you to
to
do.
do here.
Go back to treatment.
Yeah.
At RRS.
Yeah, it's still, yeah, it was on the wall.
So you get out, you get out, you get the paperwork completed.
So you'll finish.
Okay, that finishes up with the jail.
I'm sorry.
We're finished with our jail hearings, and you're completed also.
I still forget, Your Honor, I'm sorry.
Your case is completed and all the jail cases are completed.
Okay, thank you, Your Honor.
You are.
State of Ohio versus Curtis Mahan, case number CRB 25303. State of Ohio versus Nathaniel Mahan, case number CRB 25304. State of Ohio versus Andrew Mahan, case number CRB 25302.
All right, Curtis Mahan is represented by Mr. Stratton. Daniel Mahan is represented by Mr. Morford. And Mr. Andrew Mahan is represented by Mr. Smith. So we need Mr. Stratton. He's on the phone probably.
Then go to that, they have an arrest. Gotcha.
Cases are all set for trial, but I've been informed that there's been a resolution reached.
Your Honor, to please the court, I've had an opportunity on at least 2 occasions to spend some time speaking with Mr. Clarence Mahan, who's the complaining party in this matter. And I let him know previously that my intention was to not move forward with these cases. And I invited him to be here today, gave him the opportunity, told him he could address the court about it. He's still aggrieved over this, but we just felt that there was not enough evidence to go forward with it. And, you know, sometimes people who could be witnesses maybe are not willing just because of family entanglements and other things. This is
So
not.
everybody involved is named Mahan, so I assume they're all related, is that right?
Yes.
Yes,
And,
well, ex-brother, yes. After tried to kill us last year, yes, ex-brother.
So they, you know, one thing I want to say on behalf of the state was that the allegations were very serious, and because we're not going to go forward with it doesn't mean that we don't really believe that something probably happened. So we're hoping that there's no further encounters like this, especially involving guns. But we're not able to proceed, so we'll have to dismiss the charges.
So there's no objection to that?
No, Judge, no.
I want my trial.
No, I almost had one earlier.
Well, so this is a brother that was complaining?
It was a brother. We was in there last year.
Just say yes or no.
Yes.
Okay, here's my only statement. family is really important. I don't know any of the facts. Maybe it's unrecoverable. But at the end of your life, when you get there, I think we want to have those relationships. So if you can restore it, I would urge you to do that. But your cases are dismissed.
Thank you. Thank you, Judge.
State of Ohio versus Aaron Runyon, case number CRA 25271.
Thank you.
Aaron Runyon.
Mr. Shred's case, on hearing here.
You give me that. Yeah, that's
Good report. Is this someone that you're considering for QRT?
Your Honor, I've had him in QRT and I terminated him. He did have a positive screen and used methamphetamine and would not admit to the truth, so
Okay.
I terminated him.
All right, so what's the state's position on how to go forward with this?
Well, so it sounds like he's having a positive interaction with RRS.
Is this,
And they're not-
what was the screen that was on? Was it
3 months ago.
Yeah, it's been a while.
Yeah.
This wasn't since last hearing.
So we're okay with him continuing with RRS as long as he keeps Kevin progress.
Yeah, we're fine with that, Your Honor.
Okay, so come back in a month,
Yes.
November 17th.
Yes, that'll work.
November 17th will be the next hearing, 10 o'clock. His report today is good.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Craig Whitehall, case number CRA 25133, CRA 25134.
Right.
This is Mr. Travis' case and the second preliminary hearing. Is it RRS? Yes.
You guys are good.
No issues whatsoever. You know when it's all complete?
I'm just talking about that. He's been on this about 2.5 months now. I'll get with his treatment team and have an answer for you all by next time.
Okay. Yeah, what's the last one on the dock?
Yeah, I'm used to that. Awesome.
Yeah.
It's a good report. What's the state's position?
We're happy that he's got a good report. His wife Amelia is here and she wants to see him at home because they have children and she feels like he needs to be home. I don't know if the counselors would agree with that at this point or how.
I spoke to him. I'm gonna get with his treatment team and see what they have to say.
So he started out with outpatient and then things didn't work and he went inpatient in August.
Right.
Does he get to interact with you and the children or?
Yeah, he does for the most part, but it's kind of hard, you know.
Well, why don't, rather than go out a month, why don't we come back sooner and see if the treatment team is amenable to him going back to outpatient.
Maybe the 31st?
Do it 2 weeks, October 31st.
Thank you.
Thank you.
10 o'clock.
State of Ohio, we call Karen Posey, case number CRB 25-546.
Mr. Cyrus case, he did do a screen when he came in.
I've not seen the screen, Your Honor.
It's better than that.
Yeah. And he reported this morning when he called me that he was running late, and he had actually been at Lawrence County Recovery this morning. And it looks like he's got a screen with today's date that matches what you have there. It's separate form, but it has the same results. So if he's getting started there, that's kind of where our concern was lying. I think it's very important that he understands that the court takes seriously the idea of treatment and of following through on that.
Well, I agree. What we want is him to follow through with his treatment, not cause any turmoil with his mother, or grandmother, or anybody else in the family, and get things together. That's what we're shooting for.
So we've been back here basically weekly for a little while. I happen to be unavailable next Friday, so I think coming back Monday would be too soon to accomplish anything.
He's gotten started. We were having trouble getting things started, so now I feel like we've got to start.
So we can go out a little further than with your permission, Your Honor. 7th of November is about 3 weeks out. Or we go even further.
That's good, November 7th.
Okay.
November 7th will be the next hearing. Keep up with your counseling. And you're living with your mother and grandmother, right?
No, he's not living there.
No, sir.
Thank you, sir.
All right, November 7th, we'll see you then. Get good reports.
I'm very good. Thank you.
State of Ohio versus Michael Davis, case number CR 825-347 A and B, CRB 25-348 A and B.
Mr. Smith's case, preliminary hearing and pre-trial.
Judge, can we just recall, I know Megan's going to talk about possible QRT, and she's been busy, haven't been able to do that yet.
You need the court's file or?
I've been there.
State of Ohio versus Casey Lynn Blevins, case number CRA 24487, CRB 24488, A and B.
Mr. Smith's case, preliminary hearing.
Yes. I'm at level 3 now too. It's like once a month now. And I'm working.
She's working also.
I have 2 jobs.
Okay. Where do you work?
I work at 52 Lounge Saturday and Sunday, and I work taking care of a lady in Barbersville Monday through Friday.
Yeah. And speak with Mr. Hill, it sounds like we're getting there, if not already, there may be one more hearing after somebody from OVP here, and it might be time to go ahead and dismiss the charge. Sounds like she's doing everything. She's been there quite a while now.
All right, let's go into December then.
Oh, perfect.
What's your schedule in December?
Let's see, Judge. I'm here the 5th.
That's
I'm
fine.
here, okay.
December 5th will be the next hearing. They will look to a dismissal then.
I hope so, Judge. It sounds like she's there.
At 10.
At 10,
Good job,
yes,
man.
10 o'clock.
December 5th. Keep it up.
You can start the new year.
Yes, thank you.
State of Ohio versus Joseph Sizemore, case number CRA 25607, CRB 25605.
Mr. Smith's case, when you're here.
It is, Judge.
That's a big ask. Well, a road check for something that was any theft. How about reduce the forgery to attempt, giving extra service, like 30 suspended. Well, they do have drugs.
Okay, okay. Judge, there's been an offer made. I think we're going to resolve the case, but I would like a chance to have him in the office to speak with me. If we could come back in November, I'm here the 17th without looking. I could look at
Okay, let's look.
Other
Our
dates.
cases there today. It's still not too bad. So we want to do the 17th?
Yeah, I've got the 14th or 17th actually open either.
14th is actually better now.
Let's do 14th, because I've got a few.
14th. Be the next hearing for Mr. Side.
Okay. I'll call you on Monday. Call Monday. We're good.
State of Ohio versus Kirsten Shipman, case number CRB 23698.
Morpheus case.
Golden.
Good.
Yep.
Good report.
Yep. Oh,
So is she living in housing that you provide or? Okay, it's a good report. Continue to monitor.
Yes, Judge.
November 14th. Are you available then?
Yes, Judge.
And it'll be as a sentencing. 10 o'clock.
Thank you.
You're welcome.
State of Ohio versus Timothy Floyd, case number CRB 17-1060.
Your Honor, if I may, I'm not sure if this phone was updated because the phone was sent to me. He came and spoke to me just a little bit ago to verify how much community service he had. I believe all of his community service is done, just on his phone.
Okay. But you still have some fines, right?
Yes, $290.
Something like that.
Okay, well, maybe you can get it finished here in the next month.
Yeah, I want to work some of it off on the community service and see what I can come up with money wise.
November 17th for sentencing. You get it finished, you don't have to be here.
All right.
Confirm it with, Mr. Cooper.
Okay. Thank you.
You're welcome.
State of Ohio versus Raymond Wall, case number TRD 23-530, A, B, and C. Raymond Wall.
Raymond Wall has been called for, he's not present. He has a bond up, so I have some sense about it. See, he doesn't have a lawyer.
Is Richard Ramey here? There was a question about whether there was restitution. So we asked for a subpoena to be issued for Richard Ramey, who was a party that had some property damage.
How do you want to proceed? Yeah, I see there was a recipe for a witness on September the 8th. Now this says, Richard Ramey, the return on it says, return to court deceased. Signed by, well, I don't know, might be Karen.
Did you say deceased?
Deceased is what it says on the return. Signed by Darren Hamlin. It was, received this subpoena on September 11, 25, and on September 11th, I solemnly vowed and signed, and that in handwriting was his return to court deceased.
I guess we've done what we can do.
So you want to dismiss Molly's case then?
Well, it was a DUS case, but there was a crash. That was why we had it.
Oh,
So I think.
So he still, yeah, so he still needs to answer for the driving under suspension, even though, well, technically, if he did damage to this guy's property, the estate is entitled to be compensated for the damage.
That is true. Well, I guess we'll have to do a,
So we'll do a warrant, okay, well, a warrant, and he's got, so we can get him back, because he's got. Yeah, he's got a bond that he posted in June. So I'll notify Mr. Sowers. He's going to here. So when did I set that other bond forfeiture on November 3rd?
I should have it down here. November 10th.
10th? Okay, November 10th on the Raymond Wall for bond forfeiture hearing.
Is it AM
Yes.
State of Ohio recalls Michael Davis, case number CRA 25347 A and B, CRB 25348 A and B.
This is Mr. Smith's case.
It is, Judge.
He was being evaluated by a QRT.
He was, Judge, I think
I'm thinking, I'm thinking on it, I'm trying to
if
weigh
we
my
can come
options.
back, he needs
Just
to.
set another date then.
Yes, we're working on it. That was going to be my
Because, I mean, I'm still with the program, I'm doing pretty good as far as that goes. I don't know, I'm kind of.
I'm going to talk to you before the next two.
Yeah,
Knock it
I
over,
like
Mr.
talking.
Smith, you can give us a decision next time. November 17th.
That will be fine, Judge.
Your time, just time to think on it.
Yeah.
We're going to
Yeah,
talk
huh?
about it. That makes sense.
I just don't want to jump to nothing right off the bat.
Do me a favor, call Sam.
I got a few questions, can you get time?
Okay, court's adjourned.
No, they haven't.
Let me draw your attention back to June the 2nd, 2025, around 12:29 a.m. in the city of Detroit, in the area of West Grand Boulevard and Jeffries Highway. Did you have an occasion on that day to come encounter with the Detroit Police Department?
Yes, I did.
And were you operating this motor vehicle?
Yes, I was.
They also asked you to produce a valid driver's license.
Yes, he did actually.
You couldn't do so, could you?
No, I couldn't.
Why is that?
I didn't have I didn't have one, Your Honor.
Very well. Find your client guilty of the amended count of failure to display. Stipulate the proper call, dismiss the other matter.
So stipulated, Your Honor.
All right, 240, Mr. Long, when can you pay it?
We'll have to take about a month. I'm not working right now. It's possible.
I'm gonna give you 30 days to figure it out.
Yes.
November 17, 2025, I'll leave a mark to file, allow payment plan. You can pay it at any div that kiosk in the city of Detroit. I'm told you can upload the div that app to your phone, or you can come on down to the courthouse and pay it in person. Those are the two best ways I can tell you to pay it, Mr. Long, or come on down to the courthouse before that date or by that date and get into a payment, okay?
Okay. You was like going in and out. I apologize, Judge. You did say November the 17th?
November 17th, I said that I will allow a payment plan as well. You pay it in your DivDat kiosk in the city of Detroit. I'm told you can upload the DivDat app to your phone, or you can pay it in person down here at the court. Those are the two best ways I can tell you to pay it. Or you can, or I'll mark the file, allow payment plan, and I'll let you come in with that payment plan. You get in here, you have to come down to the court and set that payment plan up before the 17th, okay? I mean, yeah, 17th, right?
Oh, okay, I got you. Okay. Gotcha.
wish.
And that's $240.
Yeah,
Yeah.
you owe some other money too.
Pardon me?
Owe other money that you entered into before that you haven't paid, but 240 for this case.
Yes, yes, sir. Yes, sir. Also, I had made a deposit on the last one, but yes, I got you. I know
Very
this
well.
is added on to it. Thank you.
Best of luck to you, Mr. Long.
I appreciate it. You too. Have a great day, Judge Perkins.
Mr. Brandon Love.
Yes, Judge.
Good morning to you. You're not required, take your hat off, sir, please. You're not
Hello?
required to be here. Mr. Long, you're free to leave. You're free to leave.
Okay. Thank
You're not required to be here until the 27th of October. We can accommodate you just to get you another date and get it on track again. I believe you missed your court date. So,
What? Judge, you said I missed the court date. Last time I talked to you, I thought you said October the 21st, but I had received something in the mail that said October the 17th.
you gotta write it down. I see that you were arraigned on October the 9th at 1:30, and I don't see any other entry in here at all. City of Detroit versus Brandon Antoine Lamar Love, case number SP 1787.
Oh, no. That's not me, Judge. Lamar, no.
What's your middle name?
My name is Brandon Anton Love.
Anton. Brandon Anton Love. 22789, correct?
Yes. Oh, and what they have my name wrong is Brad. How they pronounce it? Brandon Love. They had corrected it.
It's not this,
So it's Brandon, BRDON.
ADON, right?
Yeah, BRADON, Anton Love.
That stuff is set for trial on the 21st,
Okay.
but we still have a problem. Brandon Love, BRANDON, that's you as well, right?
Okay.
I'm asking.
Yes.
And that date of birth is the 289. So let's see what these cases are. Or are they the same? Ms. Mathis, can you help me out? I have Brandon Love. $27.89. Braden Love. I think it's all the same. One, two. Yeah, you can run it. But I think I see, it doesn't matter. Pull it up by the driver's license. So everything comes up. Everything comes up.
Excuse me, Your Honor.
Hold on a second, Ms. Lomax.
Okay.
You good?
Okay, I think we're good. think we're good. And his driver's license is valid. One more second. We need to change that.
Say it one more time.
We need to change that to Mr. Graves. All right, I'm satisfied to know that that stuff is all supposed to be heard on October 21st, 2025 at 9 AM. Mr. Brandon, is it Brandon or Brady?
It's Brandon.
How does it say on your driver's license? Yeah, you know what a driver's license looks like.
I just got a new one.
Anton.
Yeah, Anton. It's Brandon. Because they go off of my social, and then now they're going off my original name is Brandon, but now they're going off the name that was printed on my birth certificate.
All right, very well. October 21st, sir. Best of luck to you. And we'll see you back October 21st at 9 AM.
All right, thank you, sir.
Well,
Are we updating you?
no, we'll just leave it alone.
Oh, just make sure I follow.
Let's go back on the record with Miss Bradfield. Miss Lomax, you're supposed to be in the breakout room with Miss Bradfield. All right, Mr. Barry, who you have?
I have no one, Your Honor. My last was Mr. Long.
Where's call the city, please?
Yeah. I was just like, wash your hands and forget the Austria.
Somebody's gonna have to turn their television down. Or off. City of Detroit runs license. City of Detroit versus Rayona Lindsay, case number SP 176 47151. Appearance for the record, please.
Elwood S. Berry Jr. on behalf of the defendant. State your full name, Ms. Lindsay.
Rihanna Lindsay.
Rihanna Lindsay, I'm sorry. Good morning to you. Day and time set for a pre-trial. Ms. Lindsay, Mr. Berry's gonna try to get you an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to a trial. I'm gonna put you in the breakout room and I'm gonna let us know what you wanna do when you come out.
Okay.
And she's in there, Mr. Berry.
Yes, sir.
Ask the matter. What are we doing now, Mr. Goffman, on Destiny Graves?
Okay,
Ready.
All these tickets, she showed documentation for.
Well, the prosecutor has expressed that they're not willing to pursue the cell phone case if she has proper documentation of driver's license, registration, and insurance. She does have valid driver's license that can be confirmed, and her registration and insurance she showed to me back in July, Your Honor.
July.
Yeah. I don't think there was ever an issue with respect to those documents.
Okay, and good morning, Mr. Boffman, who's your client?
Hi, Destiny Graves, she's not on today's docket. That's
Okay, got it.
She was on yesterday's docket. All right, City of Detroit versus Destiny Graves, case number SP 1069059, counts 1 and counts 2. SP 1724781, SP 1724805, counts 1, 2, and 3. SP 1724836.
Please.
Tyler Goff.
All right, Mr. Goff, we'll call your case. This is the state of Michigan versus Tyler James Goff, set, file 20-34890-FY, set for a bench warrant arraignment. Mr. Goff, there was a bench warrant out for your arrest. It alleges that you failed to appear for an order to show cause on September the 4th of 25. Bond was set in the matter as $1,000 cash as surety. And it's alleged also that you owe $776.54 on your prior sentence in this file. Where were you on September the 4th?
So I really don't recall getting paperwork for the court date, but I probably did and just threw it out or misplaced it or something.
Well, what's your plan for paying off this debt?
So I know I can have family help me. I've been wanting to try and find a job because I haven't worked as much since COVID hit. So that was about 5 years ago. I barely worked in the last 5 years, barely. Post to before. So, but I have family that can help me pay it, but I'd like to find a job, find something for work. That way I have some of my own.
What's stopping you from finding work?
So I lost my license too, and then just haven't exactly, but I just haven't been trying the best, I just need to try more.
I have notes in the court file where I've had contact with you about this beginning in March, 7 months ago. We talked about having a court-appointed attorney. We talked about getting an attorney for you. There in March, again in April, twice in April, again in May, again in June, and you were arraigned in front of Judge Hunter in August. And in September, you failed to show up, and here we are in October. How long before you get the clue, Mr. Goff?
Guess I just need to try a little harder, man.
Well, it's either that or we keep picking you up and throwing you in jail. How's that sound?
More of that.
I mean, that's what's going to happen. If you keep not showing up and not making your payments, we just keep picking you up and throwing you in jail. I mean, that sounds pretty stupid to me, but is that what you want to do?
I know. No, not really, man, but
Well,
I mean,
let's get this paid off, dude. It's less than $1,000. It takes you what, 20 hours worth of work, 10 hours worth of work. And that's at minimum wage. That's a day and a half worth of work. 2 days, maybe.
No.
Come on, man. Where are you living at right now?
At home, mom and dad.
Which is where?
3325 Old US 27 North.
So are you telling me that you don't have anybody that you can borrow $776 from to pay this off, so you don't have to worry about going to jail?
I probably do. I mean, I probably do. I probably can.
You got any money right now that you can pay?
Not me personally, not in my own person.
How much can you pay in 2 weeks?
Maybe couple hundred, 200-300.
Don't just tell me a story. Tell me something that you know you can make.
Between 1 and 300. At least 100, if not a couple. If not 200-300.
Have I got any time at all on the 30th?
Yeah, we got some room in the afternoon on the 30th.
All right, Mr. Goff, I'm going to reschedule today's hearing for October the 30th. I'm going to let you out on a PR bond today. You're going to show back up on October the 30th at 1:30. You're going to have paid $100 by then, or I'm going to cancel your bond and you're going to go back to jail. All right? And we're going to do that again. We're going to do that again the next 2 weeks until you get it paid off. So every 2 weeks, you're going to see me and you're going to pay $100 or more until you get it paid off. Otherwise, you're looking at going to jail. You understand?
Yep.
All right. That's all for today. I'll see you in 2 weeks. The paperwork will get over to the court to the jail this afternoon, and they'll let you out.
Cool, man. Thank you.
All right. I don't have a new bond.
Who's next, Your Honor?
Tasha Butts, please.
Action sheet.
Yeah, I did at the bottom. Can I have your name, please?
Tasha Butts.
All right, Ms. Butts, we'll call your case. This is the State of Michigan versus Tasha Butts. That's file 25-43956-SM-3. Ms. Butts, there are two things pending in regard to this case. One is in motion in order for show cause because you failed to appear on 10/6 of 2025 on the underlying charge that's been made in the complaint against you. Why didn't you show up for court when you were supposed to?
I was in a hospital again.
Which hospital were you at?
I was taken into the Otsego Memorial and I was transferred to Sheboygan Hospital.
What time period was that?
10/5, I went in on a Sunday night here in Gaylord, and then I was admitted into the Sheboygan on 10/6.
All right, I will dismiss the order to show cause against you because of that medical treatment.
Thank you.
So what I'm going to do then is I'm going to arraign you on the underlying charge in this file. So I'm going to tell you what you're charged with. I'm going to tell you what your rights are, and then we're going to address the issue of bond. The complaint made against you says that on or about July 26th of 2025, in Bagley Township of Otsego County, you did commit the following two offenses. Count one is called Mail and Mail Depository Protection Act theft. It says that you did take, hold, conceal, or destroy mail addressed to another person, that being Jada Gray, with the intent to deprive that person to whom the mail was addressed of the mail. That's contrary to Michigan compiled laws. That's a misdemeanor offense. It has a maximum penalty of 1 year and or a $500 fine. You understand the name of the offense in count one?
I do.
You understand the maximum possible penalty in count one?
I do.
Count two says that on that same date, time, and place that you did litter on private property, in that you did dump, deposit, or place filth, garbage, or refuse on the grounds or premises of 6 McCoy Road and 10 McCoy Road without the specific permission of the person or owner thereof. Contrary to the Michigan compiled laws, that's a misdemeanor offense. It has a maximum penalty of 90 days and or a $500 fine. You understand the name of count two?
I do.
You understand the maximum penalty of count two?
I do.
All right. As to each of those offenses, you have the following rights. You have the right to plead guilty, not guilty, or to stand mute. You have the right to have an attorney represent you, and you have the right to have a trial by a judge or a jury. As to your trial rights, those include the right to see, hear, and question the witnesses against you, the right to present your own witnesses and evidence and get an order from the court called a subpoena to require witnesses to appear and testify. You could also testify, or you could remain silent, and if you chose to remain silent, that silence could not be used against you. You'd also have the right to be presumed innocent until proven guilty beyond a reasonable doubt, and to have that burden of proof remain with the prosecutor at all times. Finally, at a trial, you'd have the right to automatically appeal any error. However, if you enter a plea in the future, you'd be limited to asking the court for permission to appeal. Do you understand all of those rights?
I do.
Do you have any questions about any of those rights?
I do not.
Mr. Brown, have you had a chance to speak with Ms. Butts as to an attorney? I'm sorry, Mr. Brown, you're on mute.
I apologize to the court. Yes, I have, Your Honor. She would qualify. She has requested an attorney, and that information has been sent to Mr. Gila's office.
All right, Ms. Butts, I'm going to honor that request, and we'll appoint an attorney for you. While we're waiting for that to happen, I'm going to enter a not guilty plea on your behalf in order to protect your rights. I'm also going to set a pretrial conference so that your attorney can meet with the prosecutor and see if there's a way to quickly resolve the case. Now that we've done those things, we're going to turn our attention to the issue of bond. I'm going to ask both of the attorneys to tell me their thoughts on bond, and then I'm going to give you an opportunity to tell me what you want me to hear as well. So, Mr. Fortier, your thoughts on bond? You're on mute, Mr.
Sorry, I was
Fortier.
on mute. She doesn't have a significant criminal history. I think a 5,000, 10% would be more than sufficient. I mean, That's what I would ask for. In addition to that, no contact with the listed victim in the case, which is Jada Gray. I don't know if she knows who that person is or not, but.
All right. Thank you. Mr. Brown, your thoughts?
Your Honor, Ms. Butts is 40 years old. She does live locally here. I don't think she's any kind of a flight risk. She did speak of going to the hospital. I wanted to inquire of her a little about that. And these were not physical issues. I think she's dealing from some mental health issues. She is currently on some medication for those. I want to make sure that while she's incarcerated, she gets the medicine that she needs. There's some, I won't go into it on the record here, but there are some rather significant mental health issues. It is my understanding that she does have some CMH appointments, maybe some appointments with the doctor set up coming up soon. She has 3 children. I would ask the court to take those things into consideration when setting a bond. I do want to make sure that she is able to attend any appointments or at least get the mental health treatment that she does need.
All right, Ms. Butts, you also have the right to address me as to bond. I would simply caution you about making any statements about the underlying facts of this case, because that might be used against you, and we are recording this. But other than that, I'd be happy to hear from you your thoughts about whether or not you would appear and why.
I would definitely appear. I was in the hospital, and I've even tried to call from my parents' landline to maybe at least address that I knew I had a warrant. I was just walking downtown yesterday. I'm not in hiding. I'm here to take care of everything that I should. I don't know necessarily if I could just keep the bond that I was on prior to, since I was in the hospital and I wasn't doing anything illegally or to obstruct my bond is all. So I don't know. Other than that, I would just ask the court to maybe take that into consideration, that I'm not a flight risk. I'm at home. I've been job searching. I have my appointments in line.
Are you working with a doctor or with community mental health?
Both. When I got out of the hospital, they set up an appointment with CMH, and then I went and set up an appointment with Bear River. Well, I got her cards, yes.
And are you actively participating in those things?
Well, I haven't been able to because I was in the hospital another week. So I've been like in a hospital and then I was out and then I'm in. I'm trying to actively be in it, yes. That's why I'm glad this will be over with. Eventually.
All right. Is there any other information that you want me to be aware of?
Just that I'm at home taking care of my daughter, my 15-year-old that really needs me right now. I'm trying to get her in line too, on top of my health issues, mental health. So I feel like it might be more burdensome to keep me here. If my parents are taking care of her when I'm not there, so that's stressful too. But I'm just asking to take into consideration me being the mother and an upstanding citizen to take care of this the right way.
All right, thank you.
I don't have the funds. I would have to ask my parents is all I'm gonna say. That was the end of it. I'm sorry.
I'm going to set a $2,000 personal recognizance bond. That means that you do not have to post any money up front, but if you fail to appear, then you would owe the court $2,000.
Okay.
In addition to the money issue, you will have to appear for every court date that's scheduled by the court. You must abide by any judgment of the court. You may not leave the state of Michigan without permission of the court. You may not commit any crime while on release. You must immediately notify the court in writing of any change of address or telephone number. You must participate in your specified treatment program for your mental health. That includes community mental health, doctor's appointments, and medication. So that means if CMH or one of your doctors tells you to do something, you got to do it as a condition of your bond. And if you don't do it, it's a violation of your bond.
I understand.
And then there will be, you may not have any contact with Jada Gray. That means not in person, not through other people, not on a computer, not on a phone, not through social media. No contact means no contact. All right, we will process this paperwork as quickly as we can, get it over to the jail. And then once you receive it and sign for it, you may be released. Any questions, ma'am?
No, thank you
All right.
very much for listening.
Good luck to you. Officer, the next one will be Carly Price.
All right.
Thank you. Have your name, please.
Shirley Price.
All right, Ms. Price, we'll call your case next. This is the state of Michigan versus Carly Price, file 25-43882. We also have file 25-44052-FY. Man, the last case I called is a new case against you, so I'm going to arraign you on that one. And then we'll move to a resolution or try to get a resolution in the older case that's against you as well. In the new case, I'll tell you what you're charged with, tell you what your rights are, and then we'll address the issue of bond. So the complaint in the new file against you reads as follows. It says that on or about July the 7th of 2025 in Bagley Township of Otsego County, you did commit the following 4 offenses. Count 1 is controlled substance delivery or manufacture of methamphetamine. It says that you did deliver the controlled substance methamphetamine contrary to the Michigan compiled laws. That is normally a felony offense of 20 years and or a $25,000 fine. However, the prosecutor has also filed what's called a subsequent offense notice, which doubles the penalty. It says that you were previously convicted of violating the Controlled Substance Act by delivery or manufacture of a Schedule 1, 2, or 3 drug on or about 2/5 of 20, and therefore there is a sentence enhancement to double the underlying felony penalty, and that penalty is now up to 40 years and or $50,000. You understand the name of count 1?
I do.
You understand the maximum penalty to count 1?
I do.
Count 2 is the exact same charge, and it says that you did commit the crime of controlled substance delivery or manufacture of methamphetamine, in that you did deliver the controlled substance methamphetamine contrary to the Michigan compiled laws. Again, it normally would be a felony of 20 years and or a $25,000 fine, but the same subsequent offense notice has been given, indicating the same offense, possession of methamphetamine on or about 1/14 of 2021, and therefore you are subject to an enhanced penalty of up to 40 years and or a $50,000 fine. Do you understand the name of count 2?
I do.
You understand the maximum penalty for count 2?
I do.
Count 3 says that you did, is the name of it is computer network or communication to do a crime with a maximum over 1 year and a between 1 and 2 years. And it says that you did use the internet to communicate with a Mr. Portier. I assume that that's a confidential informant, CI.
Yes.
All right, so you did communicate with a confidential informant for the purpose of committing a controlled substance delivery of methamphetamine contrary to Michigan compiled laws. That is a felony offense, has a maximum penalty of 2 years and or a $5,000 fine. Could also require reimbursement to the government for expenses incurred in violation of statute, and could be consecutive to the sentence imposed for a conviction on the underlying offense. Do you understand the name of count 3?
I do.
Do you understand the maximum penalty for count 3?
I do.
Count 4 is similar to count 3. It alleges computer or a network or communication to do a crime with a maximum penalty between 1 year and 2 years. And it says that you did use the internet to communicate with a confidential informant for the purpose of committing a controlled substance delivery of methamphetamine violation. Again, that's a 2-year felony offense with a maximum penalty of 2 years and or a $5,000 fine, reimbursement of the government for expenses, and could be consecutive to the underlying offense. Do you understand the name of count 4?
I do.
And do you understand the maximum penalty for count 4?
I do.
Well, it looks like I missed a count as well. There's a count 5. Before I get to that, all of these counts 1 through 4 are felony level offenses. Do you understand that?
I do.
Because of that, even though there are drug enhancement charges on them, there's also been filed against you a habitual offender notice, which is another way to enhance the sentences against you. And it says the following, that you were previously convicted of 3 or more felonies or attempts to commit felonies, in that on or about May the 9th of 2013, you were convicted of operating while intoxicated or impaired third offense felony in the 46th Circuit Court for Otsego County in the state of Michigan. And then on or about February the 5th of 2020, you were convicted of the offense of controlled substance delivery or manufacture in the 46th Circuit Court for Otsego County in the state of Michigan. And then on or about January 14th of 2021, you were convicted of the offense of controlled substance possession of methamphetamine in the 46th Circuit Court for Otsego County in the state of Michigan. Therefore, if any of the underlying offenses have a penalty of 5 years or more, your penalty becomes up to and including life imprisonment. Do you understand that?
I do.
And if the underlying offenses have a penalty of less than 5 years, then the new maximum penalty is up to 15 years in prison. Do you understand that?
I do.
All right. There is one more charge that the prosecutor has made, and it is a misdemeanor charge. It's count 5, and the name of it is driving with license suspended. And it says that you did operate a motor vehicle on an area designated for the parking of motor vehicles, that is the Myers parking lot, while your operator's license was suspended or revoked. That is a misdemeanor offense. It has a maximum penalty of 93 days and or a $500 fine. It also involves vehicle immobilization. Do you understand the name of count 5?
I do.
You understand the maximum penalty for count 5?
I do.
All right. As to each of those charges, you have the following rights. You have the right to plead guilty, not guilty, or to stand mute. You have the right to have an attorney represent you, and you have the right to have a trial by a judge or by a jury. If you wanted to have a trial, you'd also have the right to see, hear, and question the witnesses against you. You'd have the right to present your own evidence and your own witnesses and get an order from the court requiring those witnesses to appear and testify. You could also testify, or you could remain silent. And if you remain silent, that could not be used against you. If you also at a trial, you'd be presumed innocent until proven guilty beyond a reasonable doubt, and that burden of proof would remain with the prosecutor at all times. Finally, at a trial, you have the right to automatically appeal any error at that trial. However, if in the future you enter a plea, you'd be limited to asking the court for permission to appeal. Excuse me. You understand all of the rights that I've just given you?
I do.
Do you have any questions about any of those rights? All right, Mr. Dick, I see that you are her attorney on the current case that's pending against her, 25-43882. I assume that you'll probably be appointed on this new case as well. Would that be a safe assumption?
Yes, I believe so, Your Honor.
All right, Mr. Brown, did you talk to Ms. Price about appointed counsel?
I did, Your Honor, and she did mention that Mr. Dick was her attorney. I sent that information to Mr. Gilo's office. She does qualify, and that is my assumption as well. So if it's okay with the court, I am going to defer to Mr. Dick, who I'm sure knows much more about this particular client.
All right. All right, Ms. Price, until you've had an opportunity to speak with Mr. Dick about this particular case, I'm simply going to enter a not guilty plea on your behalf in order to protect your rights. Because these are felony matters, I'm going to set a couple of court hearings in quick order so that your rights are protected as well. The first one is called a probable cause conference. That'll happen in the next 7 days, and Mr. Dick and the prosecutor will meet and try to resolve the case quickly. If they're not able to do that, within the next 21 days, we'll have a preliminary examination scheduled. That's a short hearing in district court. In front of me is the judge, where the prosecutor is required to show a small amount of evidence called probable cause that you've committed the crimes that you've been charged with. That is not a determination of guilt or innocence. It's simply a check to make sure that there's enough evidence for the case to proceed. Do you have any questions about either of those court proceedings?
I don't.
All right. What we're going to do next then is turn our attention to bond, and I'm going to ask each of the lawyers what they think bond should be set at, and then I'll give you an opportunity to tell me anything that you want me to know about bond as well. So Mr. Fortier, as to bond.
Judge, before I put the number out there that I'm going to ask the court to order for her bond, I do want to just make note of her prior criminal record. So in 2011, she was convicted of OWI twice, along with an MIP twice. In 2012, she got another MIP. In 2013, she picked up her OWI, third OWI, where she was charged with a felony. In 2013, she had a drunken disorderly and another MIP in 2020. I believe it was in 2021, she was convicted of 2020, she was convicted of delivery or manufacture of cocaine. In 21, she was convicted of possession of methamphetamine as a second or subsequent drug offender. Most of those occurring here in Otsego County. She's also got the pending case, which occurred after the fact, after the alleged offense dates in this one. So she's got the possession of methamphetamine, where she's charged as a habitual second offense notice, which should actually be a little higher, but then she's also got her the drug double. And in this offense, she's charged with 2 counts of delivery of methamphetamine as a second or subsequent drug offender, which puts her potential penalty at up to 40 years. These are not insignificant offenses. She has a history of delivering controlled substances. And in particular, in the case in front of the court right now, the first alleged buy or delivery of methamphetamine on July 7th was for a total of 14 grams of methamphetamine. However, she only actually delivered 4.4 grams, even though the full amount of the 14 grams was paid for. And the second buy in our county was on July 15th, where she delivered 7.2 grams of methamphetamine. These are not insignificant amounts of this very dangerous controlled substance. With her history, with the amounts that she's dealing. I also want to point out to the court that in the first buy on July 7th, she actually had her child in the car when that methamphetamine was delivered. So not only is she delivering dangerous drugs in our county, she's doing it in front of her children. I think an amount of $50,000 cash surety would be sufficient because she's facing significant prison time if she's convicted and she's got a history and there's a need to protect the community from her continued behavior. So in addition to that, I would ask that the court order no drugs, no alcohol, no controlled substances without a valid prescription, not to be in any bars, and to report via community corrections where she should be testing on random testing.
Thank you. Mr. Dick, as to bond.
Mr. Honor, while her criminal history is not insignificant, however, she is a mother. She does regularly work. We would ask that the court considers perhaps allowing her to be under some sort of house arrest with the ability to go to and from work, doctor's appointments, and court appointments with perhaps a GPS tether. As far as anything else goes, her employment definitely does not afford her the ability to post a bond for a $50,000 cash surety.
Ms. Price, you have the right to address me as well. If there's anything that you want me to be aware of, I would simply caution you not to make any statements about the underlying case or the underlying facts, because this is being recorded and I don't want it to be used against you later. But if there's anything that you'd like to tell me about your ability to appear, your ability to post bond, your employment, your finances, those kinds of things, I'd be happy to hear that now.
Yes, Your Honor. I just wanted to say that I do work full time. I do have my child full time, and I have always shown up to court dates in the past, and to just keep that in mind. That is all.
All right, thank you, ma'am. All right, I would note in the previous file that bond is set at, and that's file 43882 FY. Bond is set at $5,000 PR, and the allegations in that case are possession of amphetamine or methamphetamine with a drug double and habitual second, and then driving with license suspended. Much less serious, but she's been out on bond, much less serious in the current charges, but she's been out on bond, I believe, since July on that matter. This current file appears to be from the same time period, at least the alleged date that it occurred is 7/7, and I believe the date of the previous file 7/20. So this more, the current file that we're addressing today is actually precedes the previous one. And while I'm well aware of the felony record of Ms. Price, if she's been out for that amount of time on a lower bond, I don't know that she's going to be much more of a danger to the community or fail to appear now, simply because we've brought more serious charges. There is some concern I have that because of the much more serious charges, she may not appear and try to get away from the penalty for that. So I will enlarge the bond, but I'm not going to go up as high as the prosecution requests. Having said that, Ms. Price, if there's any deviation, that is failure to appear, any bond violations, anything, whatever, I'm going to take that as that I was wrong and you need to stay in jail until your case can be resolved. Do you understand what I'm saying to you?
Yes, Your Honor.
So it is absolutely paramount that you keep your nose clean, that you do what you're supposed to do, you be where you're supposed to be, you keep in contact with your attorney, and you cut ties with whoever or whatever has caused you or may have caused you in the past to become in contact with the police. You can't afford to be in jail if you've got a child at home. And I'm not gonna have you out there continuing to do this. Not gonna say that you do, but can't have this kind of stuff on the streets, period. So I'm gonna set bond at $5,000. Cash surety or 10%. That means you got to post $500. You also have to appear at any court date scheduled by the court. You must abide by any judgment of the court. May not leave the state of Michigan without permission of the court. May not commit any crime while on release. You must immediately notify the court in writing of any change of address or telephone number. You may not use alcohol or illegal controlled substances. Must participate in a substance abuse testing or monitoring program through community corrections, and that would be random testing. You may not enter a bar or place where alcohol is sold by the glass. You must report to community corrections, and the jail will give you that number to call upon your release. They're the people that monitor the people who are on bond on felony cases for the court. So you'll need to know when to call in, when not to call in, how to get a hold of them, and how they get a hold of you. I am giving you somewhat of a break, Ms. Price. Don't screw this up.
Thank you, Your Honor.
All right. Then, Mr. Dick, as to file number 25-43882-FY, that matter was adjourned to today's date. See if we had a resolution. Where are we at with this case?
Your Honor, in light of the new file being opened, we are going to ask for this to be continued just to allow us to try to work out some sort of a global resolution to these cases.
Next time we have some time available.
So her new case will be back on 10:30. 1:45, so we can schedule that at the same time.
Yes. All right, Mr. Dick, we're going to put these together on October 30th at 1:45.
Very good.
We'll
Thank
have
you, Your
both
Honor.
cases together at that point. This current case is getting really, really old, so I need a resolution of that. So let's make sure that you've talked to Mr. Fortier. Mr. Fortier, if you put a note on your file or whatever needs to be done there so that the two of you talk and we do everything in our power to reach a resolution. Obviously, Mr. Dick has to get the permission of his client, and if that doesn't work, it doesn't work. But I'm going to want to set preliminary examination dates or something to get the cases moving, simply because the other one, the current one that I'm looking at now, 43882, is back from July, and it's been a long and winding road and needs to be taken care of. So let's get a deal. If we can't get a deal, let's get a prelim date set. All right. Thank you. That's all for today.
Thank you, Your Honor.
Deputy, if we could have Chelsea Brink brought next, please.
Yes, sir.
Thank you.
Want me to let everyone else in?
Yeah, that's fine.
Okay.